Call the list.
Adjournment item number 1.
This court finds that the defendants have unequivocally admitted the claim of the plaintiff and nothing remains to determine the present suit. In view of the above, plaintiff is entitled to get a decree of rupees 65,29,084 along with interest at the rate of 10% per annum from 4th April 2018 till realization.
I'm graded.
Number 2.
But I am for the petitioner in this matter. But these are those originating summons suits.
Application dismissed. Application dismissed.
Application of the suit. The application is dismissed. We're grateful.
Number 3.
Application dismissed. क्या फिक्स में काम है मैं तो बोला नहीं कौन से फिक्स मैटर आया कौन से फिक्स मैटर आया नहीं हम 10:30 मना कर दो फिक्स मैटर करने के लिए दिखाएं कैसा है ये नो Call list call.
Mention item number 4.
Item number 4. No, non-commercial.
Item number 1.
कहाँ से लाए इनको? Yes.
Millard, this is Millard, an application taken out in that originating summons suit, Millard.
Yes.
It might come back to your lordship, Millard, that I wanted to move it when Mr. Rai intervened and said that I need to be served. So we have served it. My learned friend is appearing.
My lord, I am opposing
You
it.
also filed an application.
My lord, only one, my lord, perhaps, my lord, it will be in proprietary of things, my lord, I must also point it out. My lord, from one of the earlier orders, my lord, in connection, my lord, with the origin summons suit, my lord, an appeal, my lord, was preferred, my lord, by us. Because, my lord, passed an order, my lord, in origin summons. That, my lord, is, my lord, it's number 1, my lord, before, my lord, the division bench. So, I think it's best, my lord, that at least, my lord, we wait because...
Against this order?
No, my lord, against the earlier order, my lord, passed in the similar kind of origin summons.
Interim order.
Yes, yes. Because there, my lord, will recall, my lord, the origin summons suit filed earlier. Then, my lord, they came and, my lord, got, my lord, an order, my lord, from my lord, because relying on one of the
Today?
judgments. Yes, my lord, just, my lord, for judgment today.
For judgment.
For judgment today. So, my lord, I think it's, my lord, best, my lord, I think, my lord, in my respectful submission, my lord, proprietary demands, my lord, we can wait, my lord, to find out, my lord, what's...
Millard, what Mr. Banerjee has submitted is factually correct, but it has no bearing so far as this. That's a different trust, different matter, it's a different suit, and
But
obviously
similar issues, I mean, if I may say so. With
the points that they have, in fact, they have taken one point, but I don't want to repeat what points they have taken before the appeal court, but we are not on that.
No,
But
correct.
so
No,
far as,
one of the point taken was there's no GA which was filed also. That's
Yes.
correct. So now, my lord, they filed, my lord, after we've taken the, but they filed, my lord, an
they have
application.
filed an application.
Whether, my lord, that also makes it curable or not, my lord, that's
That's
the issue.
Okay, if it is on merit only, not because of GL, let
My lord, let us just, my lord, it's just kindly pass it over, my lord, we'll just come and...
pass it over, Millard.
and that's why I'm passing it over.
Because it will have an impact, my lord, either way, my lord. Either, my lord, we
Whatever.
lose,
Pass
win, my
over,
lord.
let it.
Very well.
Millard, can I come back at 12 o'clock because my...
12.
12 o'clock matter है क्या?
No, it's only in the event, Millard, we find that it really affects Millard, then we
Yeah,
have
but
to...
12, see, but I don't think 12 o'clock it will be taken up for here.
11?
11:30.
11.
11 है.
Because 11:30, I think I have a matter.
Okay, come at 11 then.
Right.
Commercial. Mention item number 4.
Was fixed for filing the notes of arguments. But may I just file my notes of arguments on behalf of the plaintiff number 3?
Which one? Oh,
Yeah, the partnership firm matter, Millard, which we had argued, we filed our notes, Millard.
Yeah.
It's only for filing of notes by
Substitution.
Substitution. Millard.
I filed my notes, my lord.
But I
Already
for the
filed.
legal
Yes,
heirs
filed.
of my lord, the
We've already
plaintiff number one deceased.
You are not
My lord,
filed.
yes, my lord. I'll also my lord file it, my lord. Perhaps it's on the way, my lord. I'll file it, my lord.
File. Parties and the Mr. Bhattacharya, you are for the
Plaintiff number 3, my lord.
plaintiff 3. Counsel for the plaintiff number 3. And Mr. Taka, you are
My lord,
appearing.
I am appearing for my lord, the legal heirs of my lord, the deceased plaintiff.
And the legal heirs of the deceased plaintiff have filed their written notes of argument. The
My lord, my
defendant number 2.
Different number one, the
One.
petition.
Defendant number 1 plus petitioner of the instant application already filed the written statement. CAV.
I'm very
My
deeply
lord, I'm
obliged.
filing my my lord written. It's here.
I'm deeply obliged.
Item number 5.
My lord, I appear for the plaintiff.
Yes.
I am for the defendant.
My lord, I appear for the plaintiff. My lord, it's appearing as to be mentioned at my instance, my lord. My lord, this is a suit, my lord, for recovery of money. There's no interlocutory application pending. They have the sole defendant has filed its written statement within time, my lord. My lord, we were just praying for further direction so that, my lord, the suit can proceed, my lord. Discovery, inspection, and
There's
framing
no
of.
counterclaim. There's no counterclaim.
No, my lord.
There is no counterclaim.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. It is submitted that the defendant has already filed written statement within the prescribed period. Full stop. In view of the above, the parties are directed to complete the discovery and inspection of the document within 3 weeks after vacation. 2
Yes,
weeks.
my lord, that would be.
Within
2 weeks after vacation would.
Within 2 weeks after puja vacation. Full stop. Affidavit of admission and denial of the document be filed within a week thereafter. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 2 weeks, 1 week, 3 weeks. List the matter on 27th November 2025 for framing of issues.
Deeply obliged.
Next. Call the next.
For the defendant,
Plaintiff.
the interim order is expired. And your lordship recalls, you know, this was where they had not complied with 39(3)(ab). The plaint had not been, this was an admitted position. Mr. Ray, in all fairness, also did not try to contend that
Well,
the
the
lordship had still
injunction had
extended.
till last week of August, my lord.
Today we are on, you know, they've not filed any extension, they've not mentioned nothing.
When the interim order was expired?
27th of August.
27th of
August.
August.
1 month
Today
passed.
we are on the 17th of September.
1 month passed.
My lord, after that, what has happened, my lord? I had taken out an application, my lord. Now, my lord, your lordship remembers, my lord, when I moved the matter, my lord, they came in and they said they sold it. Now, my lord, in that selling part, my lord, I obviously, my lord, there were questions as to who and where has it been sold. It was not very clear. They were supposed to put in an affidavit, my lord. They put in an affidavit, my lord. We're expecting that put in their affidavit of assets also, which they have not. I have put in an application, my lord, seeking further interim orders so that I am secured. Because, my lord, remembers, my lord, on paper, my lord, there's an admission. They are saying that they have gone to the NCLT, my lord, but on paper there is an admission, my lord. I was regularly trying to take up this matter because sometimes he could not appear, I could not, whatever it is. They took out a maintainability application. I said, I won't file any opposition, let him finish with it. And let us proceed in this one. I was
That has nothing to
beseeching your
do
lordship,
with why the injunction was not, they took no steps for extension. I am only on that today. From
My lord, I am-
28th of August till 17th of September, they've taken no steps for extension, no
My lord, the
mentioning,
point-
nothing.
my lord, my point is, my lord, I do appreciate, my lord, this matter came up, my lord. But my lord, we lost sight of the fact that it is the interim order has expired, my lord. It came up, my lord. My lord, I'm agreeable if your lordship permits, my lord, and my lord fixes a date, my lord. After vacation, fixes a date because my lord, otherwise, my
I've
lord,
done my job, but let's be fair, lordship will extend it. And keeps it after the vacations on any day for hearing of the application.
if your lordship permits, my lord. Obviously, it is
Yes,
lordship
that's right.
discretion, my lord. We cannot dictate, my lord. I am absolutely, my lord, under your lordship. Because
I don't want to take an unreasonable stand, my lord. So
My
they-
lord,
they
or
should
my lord,
have
if your
taken
lordship
steps.
take, my lord, if it not extended, my lord, kindly takes it up next week, my lord. Because truly speaking, my lord, the interim order is
No, Lordship.
neither here nor there, my lord. Your lordship understands, my lord.
That side of the
I am
ticket in
wanting some
November.
orders, my lord, which will protect me. At least let them file their affidavit of assets. Let us know whether they have anything.
No, Lordship extends
And
it
it
and
was,
keeps it
it
that
was your
side of the
lordship,
vacation.
it was your
That's what we
lordship
just agreed to.
direction, my
Now
lord,
it
that
is being.
that my lord,
What is
in
happening,
the
Mr. Ray?
opposition, they should come out with their affidavit of assets at least to show that
No,
they're
then
secure.
I'm opposing the prayer for extension.
So,
We
my lord,
just
I was
had a
just
word that I was
receiving,
going
my
to
lord.
agree to consent
Okay,
to
I
the.
am extending. Let him come in after vacation कब होएगा? देखो date कुछ है? That is the problem.
একটা ডেট ফিক্স করি না জব ফিক্স করে
12:38 कब है? 25th November you will get.
at least it will be taken up on that day, you know.
Some
That's why I'm asking. This is the date. कब है? 12:30. Record. The council, the matter is registered as to be mentioned
25th না তার আগে বলো।
as indicated in. Council for the plaintiff submit that the by an order dated 12th August 2025, the interim order granted earlier was extended till 27th of August 2025.
But
After 27th August 2025, the inadvertently the plaintiff lose the track of the suit, and as such, the matter was not mentioned for extension of the interim order. Accordingly, he prays for reimposition of the interim order, which was granted earlier, which was granted by an order dated
12th April, my lord.
12th April
But,
2025, which was extended from time to time till 27th of August 2025.
বলছি তো
Counsel can record the concession? No. Counsel for
I
the,
oppose. Look, may
counsel
I?
for the defendant raised objection and submits that the interim order expired on 27th of August 2025, when the plaintiff has not taken any step till date for extension of the interim order. Only on the verbal submission of the plaintiff, the interim order cannot be reimposed. But the learned counsel for the parties peruse the order dated 16th April 2025, wherein initially this April 2025, 16th April 2025, wherein this court has granted interim order, and the said interim order was extended from time to time. The interim order is only with the nature, the interim order only with regard to
Alienating.
by an interim order, this court directs the defendants, their men and agents, servants and representatives not to alienate an encumber or dealing with the property and creating any third party interest over the said property. This court find that none of the party will be prejudiced if the interim order is extended till the next date of hearing. The above interim order is an interim order dated 16th April 2025 is reimposed till 7th November 2025. Let the matter appear on 7th November 2025 at 12:30.
And I'm so grateful, man. Very grateful, man. This matter is, well, your lordship can see the pressure I am on. I'm very grateful, man.
7 November.
7 November, 12:30.
One more submission, my lord. GA number 1 and 2, my lord, may be permitted to file my affidavit in opposition.
Reply? Yeah, yeah.
Defendant has filed affidavit in opposition in connection with GA1 and GA2. Let the same be kept with the record.
And I am not going to file any opposition to GA3, my lord. The main remedy application I've already said so, my lord.
GA3, okay.
Very grateful, my lord. Very grateful.
Item number 7.
I don't know, sir. I'm for plaintiff, my lord. As per lordship direction, we have made that corrections, my lord, in para 26. We have written that we will not proceed against defendant number 1 to 5, defendant 1 to 4, because they are into CIRP, my lord. And 5 being a guarantor. Para 26, my lord.
Yes. Why 12? Outside.
Only the defendant is outside the jurisdiction, my lord. Rest all within the jurisdiction.
The plaintiff has filed the present suit, praying for a decree for a sum of rupees 2,08,89,305 against the decree for a sum of rupees against the defendant number 5 jointly and severally, along with interest at the rate of 18% per annum. Full stop. Counsel for the plaintiff submit that the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court. He further submit that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, he prays for leave under clause 12 of the latest patent 1865. The plaintiff further submit that the plaintiff has already initiated reinstitution mediation process, but the same was failed. Accordingly, the mediation center has issued non-starter report dated 26/6/2025. At the learned counsel for the plaintiff peruse the materials on record. This court satisfied that the defendant is outside the jurisdiction of this court and part cause of defendant is outside the jurisdiction of this court and part cause of action arose within the jurisdiction and part cause of action arose outside the jurisdiction of the court. Accordingly, leave under clause 12 of the latest patent is granted. Full stop.
Now, deficit court fees we have paid already.
That already there. The plaintiff is admitted, subject to scrutiny by the department.
I'm grateful, my lord.
Adjournment motion, item number 11.
This is my application, my lord. Order 13A, my lord, of the Code of
Yes.
the Code of Civil Procedure, my lord. Mr. Datta was leading me in the matter, my lord. We have concluded our submissions, my lord. Mr. Lakmani was
Which for the other side?
my lord. Mr. Lakmani was for the defendant, my lord. I believe he has just. My lord. I'm for the defendant.
Yes.
My lord, if your lordship will recall, my lord. This is, my lord, that matter where the question is whether the broker who introduced the owner of the property, that is my client.
Without the conclusion agreement, whether you are entitled, the broker is entitled to the.
Yes.
That is only.
And in the pleading, my lord, I have shown your lordship in the pleading that they say that the deed was finalized. Now, my lord, last occasion, your lordship put a question to me that you have yourself in 2017 signed that yes, this is what the remuneration will be. Kindly, my lord, now let me resume that. Page 71, my lord, is what your lordship, my lord, had pointed out to me. If your lordship remembers, my lord, on the last occasion.
Page 70.
Just as I was about to answer this, my lord, your lordship then called a fixed matter. Kindly, my lord, take this document. I am also sorry, my lord, today morning there was a matter for judgment, my lord. I was represented by my colleague, my lord. I could not personally make it. I'm sorry.
But against you.
Lord, my senior, my lord, has said that for a judgment, whether you're briefed or not briefed, paid or unpaid, you the endeavor is to be there.
Somebody has represented.
Wait. My lord, kindly mark the date, my lord. 31st December 2017. So LOI comes in 2017. At the stage of LOI, I am hoping that I will get this tenant. That is when, my lord, and this is, my lord, not an invoice. This is, my lord, an understanding of sorts that this is the fee that will be payable to you. And then, my lord, in 2018, that unregistered, undated lease deed is signed. My lord, that your lordship will just go to once. My lord, the lease, my lord, is at page 56. Just see page 56 for a moment at this stage.
Yes.
Now, my lord, kindly see this lease deed. This is an undated lease, number 1.
Correct.
Then, my lord, if your lordship turns to page 58,
Yes.
and my lord, kindly see, my lord, I'm sorry, page 57. Page 57, right at the bottom.
Yes, your
I've shown your lordship, page 50. Yes. And my lord, then even it continues on the next page.
Yes.
That if there is no termination of the main agreement with the between the developer, that is me, and the purchaser,
Yes.
then this will not go through. And then kindly see, my lord, 1, lease.
Hmm.
My lord, this was to be a lease of 15 years.
Yes.
Term of the lease, kindly see 2, term of the lease, 15 years. So, my lord, a document, a lease of 15 years ought to have been registered, at least dated, if not registered. This is, my lord, neither dated nor registered. This lease was it never took effect.
Yes.
So, my lord, the point is moot, that I am introduced to a prospective lessee by one broker. If a deal doesn't work out with that broker, with that lessee, the broker could have got me some other lessee. Ultimately, if there is something that I'm entering into which takes effect,
Finalization.
then only, my lord, does my liability arise to pay. And they have, my lord, kindly see the invoice. Now, my lord, kindly see the invoice. Kindly see 72, 73, page 72. My lord, kindly see what are they charging me for. Your lordship is there at page 72, my lord.
Yes.
Kindly, my lord, see two words. Kindly mark the word they have used, my lord. Successful completion of Kalyan transaction. Where's the transaction? I mean, I have not received a paisa.
Yes.
And now, after all this pleading, my lord, now kindly take the reply. When I, in my lord, opposition, bring out these issues which are to be tried, my lord, kindly see the pleading in their affidavit and reply. Your lordship will, my lord, take my lord, kindly take page 8.
Yes.
My lord, kindly 9, page 9, my lord.
Yes.
Kindly, my lord, take 1, 2, 3, 4, 5. The 8th line from top, my lord, starts somewhere in between. I say that.
Yes.
I say that the plaintiff was merely, my lord, kindly mark these words they are using, merely obligated to introduce the Kalyan dwellers to the defendant as a potential lessee of the aforesaid commercial premises. Now the broker takes a complete U-turn and says, here, you come meet him, and that's it. And the invoice says successful completion of transaction. My lord, they have to now prove, it's an admitted position that I didn't receive a rupee from this tenant. So now, my lord, the onus is upon really, my lord, the plaintiff in his trial to prove that his obligation ended when he made A meet B, that he had no other role to play. This is, my lord, the main tribal issue in this matter.
Yes.
But I hope
But-
Mr. Lakman
but
would
I
put
want
the
to
next
now-
two lines as well, the next 2 lines of that same paragraph. I
Take note.
In fact, very well, my lord, in fact, the defendant had expressed its satisfaction to the selection of the said Kalyan dwellers by the plaintiff as a proposed lessee of such premises and had acted on the same by executing a lease agreement. My lord, all this I've already placed. As such, the plaintiff had successfully performed its contractual obligation by identifying and finalizing, as much as they might want to glorify what they've done. The fact is that there is no registered lease. Not for half a second has this lessee occupied an inch on my property, and not a paisa has come to me. And this is not disputed. Kindly, my lord, now come to page 11 of their reply. kindly come to page 11, my lord.
Yes.
Kindly see, my lord, the last sentence there. Second last line from bottom, last sentence. I say that. I say that the fact that Kalyan Jewellers did not make any payment to the defendant is of no relevance or consequence insofar as the liability of the defendant to make payment of its admitted dues to the plaintiff, insofar as the facts and circumstances of the present case is concerned.
Yes.
Again, my lord, kindly see page 13. This is the last line that I'll place, my lord.
Yes.
Sorry, second last, my lord. Two more. Page 13.
I deny.
No, my lord, kindly see page 13.
Yes.
12th line from bottom. Without prejudice to the aforesaid, it starts.
Yes.
Is your lordship there?
Yes.
Without prejudice to the aforesaid, I say that it is of no consequence to the plaintiff if the business relation between the Kalyan Jewellers and defendant did not proceed any further, and Kalyan Jewellers made no payment to the plaintiff insofar as the plaintiff's claims. My lord, I understand. My lord, kindly understand. My lord, if I had entered into the lease for 15 years and after 8 months or 9 months the lessee left, the broker could still have a case that you could not maintain your relations. But here, the transaction did not even commence. I didn't even receive security deposit, let alone rent for the first month. So this is not a case, my lord, where I was to get a tenant for 15 years, 23 lakhs each month for 15 years, and we went ahead for 1 year or 2 years, and before the lock-in period expired, the tenant left. This is not that kind of a case. Not a single rupee. And again, same thing, my lord, they have pleaded again at page 16, if your lordship will see page 16.
Yes.
12th, my lord, in paragraph 13, the 12th line, in the event, to the right, your lordship will see in the event, it starts.
Top.
My lord,
Bottom.
paragraph 13 from the top, 12th line of paragraph 13. In the event and without prejudice to the aforesaid, I say that the alleged non-materialization of any purported deal, the defendant and Kalyan Jewellers does not and cannot entitle the defendant to withhold making payment of its admitted dues to the plaintiff, as sought to be alleged. And my lord, the admission that is spoken about, my lord, your lordship, my lord, pointed out that document. So that document, my lord, at page 71 is the understanding between the parties. After that, what happened? 2018, the lease failed. There was no lease registered. And I have, and kindly, my lord, see my objections raised contemporaneously. Kindly see page 89, my lord,
Yes.
of my of the application.
89.
89. One thing, my lord, I must compliment Mr. Dotto whenever he's the other side. Everything is disclosed. My lord, kindly see page 89 in their application. This is my letter of 3rd August 2019.
Yes.
This is when the parties were going through disputes and nothing was materializing on the lease front.
Yes.
And simultaneously, I'd also held up the payment of brokerage, because why would I pay any brokerage if I'm not getting a rupee from my lessee? My lord, I'm not placing this letter, but my arguments are summarized in this letter.
Sent by you.
Yes, sent by me. And they have disclosed this. They are relying upon this document. So, my lord, I have, my lord, even when parties were, my lord, in dispute, I have, my lord, written this. And I have stated that, look, how can I pay you? Let me at least receive something. How can I pay you without even this transaction taking effect?
Yes.
Now, there is, my lord, my lord, this was, my lord, the easy part of the argument. There's a second aspect to the matter which I must bring to your lordship's notice, is that they have produced, my lord, a document of settlement. And they contend that both these parties, because of, my lord, these disputes that were there, the broker and my client came together and they signed a purported settlement, which is a document, my lord, which I'm disputing. That in that document, they decide that for a full and final settlement of 31 lakhs only, my lord, the parties have now settled. And these 31 lakhs will be paid in 3 tranches, 10 lakhs, 10 lakhs and 11 lakhs. And they also contend that they have received the first installment of 10 lakhs. So as per them, the principal outstanding, as per the settlement which was entered into, because admittedly, my lord, this deal did not go through. So the settlement, they say 21 lakhs principal is outstanding. But because I haven't been able to pay that principal of 21 lakhs, is why now they want to take an attempt at recovering the entire due, which they feel is the invoice amount for successful completion of transaction. Now, my lord, insofar as that document is concerned, now, my lord, kindly have a look, my lord, at that document.
How much time you will take?
My lord, 10 minutes. My lord.
11 or 6 another matter.
Then, my lord, kindly, my lord,
Come another day.
no difficulty.
Yes, what has happened?
So sorry, my lord.
Yes, yes.
The 11th, this matter, my lord, our matter may not happen because, my lord, I think, my lord, the
Longest judgment has been.
it's longest judgment, my lord,
We
where
don't have the text, my lord. It's being uploaded, so my lord, it's better we.
That's why I'm basically any
yes,
text
that's
is
why, my
there,
lord, I
then
thought, my lord, it's only fair, my lord, that we look at the judgment, my lord, and then, my lord,
Can be
come back and make some
Tomorrow?
I cannot fight them all the time. I need to be there.
Friday.
So if you are not there, only on that count. Thursday. Friday.
Which court? Which court?
That is difficult to itemize.
No, my lord, I'm so sorry, my lord.
Yes.
If it's possible, my lord, Friday we can also have a look at the judgment then. Friday ना वो toilet.
Friday time है क्या? 10:30 कुछ है? Fix है. 11 AM fix. कौन सा? कल fix हुआ. 11 AM. Monday, Tuesday. Tuesday कितना बजे? 12:30. Then Tuesday you have to come.
Tuesday.
12:30.
As you lordship knows,
Lord,
we're apprehending.
May I, my lord, submit this with great respect, my lord. If, my lord, can be kept on Friday, anytime, my lord, we'll also, my lord, perhaps, my lord, after looking at the judgment, we may, both sides, my lord, may need to, my lord, take, my lord, necessary steps. My lord,
Not on
because-
necessary steps. Let the matter be called up.
yes. My lord, Friday, my lord, my lord, any time, my lord, Friday, my lord, 1 o'clock, 12:30, 1 o'clock, my lord, whatever time, my lord,
Friday के 11 बजे है मैटर है.
12,
1 o'clock.
30, whatever time. So it's
110.
then since your lordship takes up these matters at 2 o'clock.
है.
2 o'clock.
2 o'clock.
2 o'clock.
तू बंदा
This is originating summons, so, my lord, I'm told, my lord,
काम है. हाँ. 2 बजे आएगा.
I'm sorry, my lord, we have so many fixed matters, my lord, has. We only,
All urgent.
yes, my lord, we only come in trouble, my lord.
No, ठीक है काम को Friday रख दो. Top में. 2:30 का.
Right. Grateful.
2 PM. Non-commercial ना ठीक है 2:30 का.
2:30. I'm so grateful. I'm so
तीनटे
grateful.
मैटर बोलो. तीनटे मैटर बोलो. All three. এটা order হবে না?
No.
Friday 2:30.
Yes, I'm so grateful.
Order.
This side, my lord, we will never change.
As per the prayer made by the counsel for the parties, let the matter appear on 22nd and 19th September 2025 at 2:30 PM.
I'm so grateful.
Yes, next. Yes, continue, Mr. Mullah.
I continue.
We'll get time. Till time 11:30 you have a time.
My client, my lord, I'll be candid, wants this to be pushed beyond the vacation. I said,
No, even though I will not complete before vacation, I have saw other briefs during the vacation.
because he's apprehensive that he may be directed to deposit the shortfall under the settlement. That's his
See how intelligent your client is.
the 21 lakh shortfall under the settlement. he's apprehensive. So he'll need time to arrange for that. But it should
Make
not come.
sure I will not take the judgment before vacation.
It should not come to that.
Complete it.
Hopefully it should not come to that, my lord. Hopefully we'll get
But
an
you complete.
unconditional. Yes. Now, my lord, kindly now just take the settlement agreement for a moment.
Settlement agreement
Yes. At page 197, volume 2 of the application. Now, before I, my lord, take your lordship through this settlement agreement, my lord, may I just give a brief background of the larger issue that, my lord, the client is facing. This property is a huge plot of land in Calcutta, owned by my client. Now, I entered into a development agreement with the Guptas, bunch of 3 or 4 persons. And the contract was that the Guptas will pay me 17.5 or 18 crores in tranches, about 10 or 12 installments. And as they keep paying, I will keep constructing. So the Guptas, there was a shortfall in payments by them. At a time by which they were to pay the entire 18 crores, they could pay only about 8 crores. Even though I had more or less finished the construction, worth about 16 to 17 crores. So, my lord, this is where disputes arose. And, my lord, parties were negotiating. There was no termination. So, my lord, I had an employee director who used to take care of the affairs of the business. So, proprietors were there, but the employee was the one who was authorized to, my lord, make decisions. This particular employee entered into an MOU with the Guptas, signing that he would pay 18 crores to the Guptas for termination of the agreement, for the Guptas to leave. And the contract says that if there is a delay on part of the payer, then I can terminate the contract only by refunding the principal whatever I had received till that day. So as per the contract, I could have simply returned 8 crores which I had received, and the agreement could have been cancelled. But this gentleman goes and signs an MOU for 18 crores, deholds the contract. The contract goes to an extent, my lord, that even if there is no delay, if I whimsically one day feel that I don't want to deal with this person and I want to terminate, then I will refund him 8 crores and plus liquidated damages of 4 crores. Even then the liability would have been 12 crores and not more. Here I was terminating because they were delaying. So 8 crores was enough. Assuming there was no delay and they are right that no, you pay us the damages, even then there's a liquidated damages clause in the contract, 12 crores. Despite that, this gentleman unauthorizedly goes and signs, my lord, a purported MOU sometime in 2018-19, my lord, to the tune of 18 crores. That did not bear the company's stamp.
So have you challenged that deed?
That MOU was kept away from us for nearly 5 years.
Whatever it
In
is.
2023, when a suit for specific performance was filed, that MOU came to light for the first time. We immediately filed a suit.
Who filed this specific performance?
My lord, the Guptas.
Guptas.
The Guptas.
Okay.
Saying that this agreement is still subsisting.
Correct.
And a precondition for this broker's money was termination of that agreement, of which the Guptas are in 2023 seeking specific performance.
Okay.
My lord,
So, yes.
so, my lord, Guptas contend that this agreement is continuing. Now, it had never been terminated. Rightly, it had never been terminated. There was never a termination from our side. But, my lord, the court held that you yourself have delayed in paying. So, the court then passed an order that we will refund 8 crores. We will give a bank guarantee of that 4 crore, the bank of the liquidated damages, because in trial it would be decided whether they were delayed or whether I defaulted.
Correct.
So that money was secured by way of bank guarantee. I paid 8 crores to the Guptas, and on this basis the property becomes free and the matter was referred to arbitration. This is the order, and until I make this payment of 8 crores and give this bank guarantee of, until then I will not deal with the property. This was the order, and once I give this, I'm free to deal with
What
the
has
property.
happened to the arbitration?
Arbitration, my lord, is continuing, my lord. The statement of defense has been filed, and my lord, suggested issues have been exchanged, and my lord, issues are to be framed in the arbitration. So, my lord, this is where the dispute with the Gupta stands. As of today, even today, my lord, because I haven't been able to pay the 8 crores plus the bank guarantee, my lord, I am in process of arranging the bank guarantee. So until, my lord, that completes, my property is still not free. So
That's why the agreement was not entered.
no, agreement, my lord, was not entered because, my lord, the negotiations which happened involved the Guptas as well. I have pleaded that because of the Guptas being unreasonable and the Kalyan dwellers also being a little unreasonable, because of the parties not being able to arrive at some reasonable conclusion, there could be no end to this. So broker, my lord, brokers introduced me to Kalyan dwellers, but the deal hasn't fructified. The broker had to ensure that the deal goes through. He's a broker at the end of the day. Now, my lord, kindly see. So, my lord, this gentleman and that agreement, my lord, the unstamped document which didn't bear the company's seal, that was challenged independently when it surfaced in 2023. I don't know whether, my lord, it's a backdated document or whether they suppressed it from us for 5 years.
So that's why that agreement was challenged. Or
that was challenged, my lord, and my lord, the court granted an ad interim injunction restraining in our suit,
giving any effect to the
document. And on the other hand, the Guptas had filed a suit that for specific performance. So both these suits collectively now are before the arbitrator, and both these suits are withdrawn. The Gupta suits are also withdrawn, and which is why such a voluminous.
So what is the claim before the arbitrator? That is not the specific performance.
No, because the High Court has made it clear, and they have accepted that offer of getting the 8 crores and the 12 lakh bank guarantee. And how can I be expected to pay and at the same time have my property stuck? That's unfair. So that's the order. I will place the order, my lord. It's an order for division bench.
What remains before the arbitrator to decide?
My lord, because under that forged MOU, they were entitled to 18 crores. And under the contract, they are only entitled to 8 crores. 8 crores, no, and 4 crores if it is proven.
LD.
Yeah, no, my lord, 8 crores if I can prove that that they delayed, the Guptas delayed in paying me, then 8 crores. But if Guptas are able to show that no, they were paying as per a timely manner, I was slow in my construction, then 8 plus 4, 12. And if Guptas are further able to prove that that MOU, that this unstamped MOU where they bought over and colluded with my employee, if they are able to prove that document which the court had on the face of it stayed, then they get 18 crores.
So how that whether that plea can be decided when the arbitrator, whether this is a forged document or your employee has.
My lord, forgery, the criminal side of it, perhaps not. But as a tort, my lord,
that is your play before the arbitrator.
That's pending before the arbitrator, my lord. But that same person who has agreed to give 18 crores, my lord, in a jiffy, that same person executes, my lord, this settlement agreement. Now kindly, my lord, see this settlement agreement. This one person, my lord, has ruined our lives. 197.
Yes.
Page 197. Now, there was, my lord, a company petition filed in the NCLT. That got admitted, where the NCLT said that the default, at that point in time, the pecuniary, my lord, limit was 1 lakh. NCLT came to a conclusion that there's a default and that you have to pay, and NCLT admitted. And this same tainted gentleman was the one representing the company before the NCLT, the colluding party. And then, my lord, after that, the matter was withdrawn. The withdrawal was not on the basis of this settlement. I will show the withdrawal order. The withdrawal order doesn't refer to any settlement. The withdrawal order doesn't even take the settlement on record. But they have also, my lord, annexed this settlement. Now, kindly see this settlement. Kindly, my lord, now, for a moment, take page 197. Kindly come, my lord, to recital D, Delhi, at 198. Subsequent thereto, the first party, through Mr. Vikash Murarka, being one of the director of BP Suraj, has approached so and so for the payment of 31. So they don't say that the company has approached. They say that this Vikas Murarka, he is the colluding party who has signed that MOU, which was stayed by the court and which is subject matter of challenge in the arbitration, where 18 crores has been offered without, where the contract says 8 plus damages of maximum 4. And the liquidated damages cannot increase any further. It's a pre-estimate of damages. Rupees 31 lakhs. So, this is now, how this settlement of 31 lakhs was arrived at as full and final settlement of the claim amount.
Correct.
And then, my lord, kindly see terms of the settlement 1.2. I'm only, my lord, placing what I feel, my lord, might be of some relevance to show my case. 1.2.
Mutually agreed 31.28.
Yes, 31.28. And, my lord, kindly see 1.2 there. How is it to be paid, my lord? A, 10 lakhs.
Payable by RTGS.
By 18 July. B, again 10 lakhs. And the last one, C, is 11 lakhs, 28,000.
By 10 September.
And it is their case in this application, my lord, under chapter 13A, that the first tranche of 10 lakhs was paid. So what is outstanding under this settlement is about 21 lakhs 28,000. Now, my lord, kindly see 1.3. This is, my lord, the most critical, my lord, part of this document. The first party, being one of the director of BP Suraj. So, my lord, the party is being referred to as a director of the company, not the company itself, which is a separate entity, distinct from its directors and shareholders. Has agreed to fund and or has provided necessary fund equivalent to the consideration amount towards the settlement envisaged in clause 1.2 above. So the entire genesis of this settlement is that one individual who created a mess in the NCLT, who colluded with another party, and who's also now signing this settlement, is the one who says that he is the one who will fund. So here, my lord, this corporate face of the company, my lord, goes. The settlement proceeds on the basis that the party, and it is acknowledging the party as being a director of the company. And, my lord, there are judgments galore for the proposition that the clauses of a contract, if there is any possible conflict between the recitals and the clauses, the clause will prevail.
So whether you challenge this agreement?
Sorry, my lord.
Have you challenged the settlement?
My lord, this settlement has been, my lord, placed before us now in this suit. In this suit, my lord, which we are defending, where your lordship is
the claim which they have made, in that claim this agreement was not referred.
No, my lord.
Given the reply, you have given the page 89.
Yes.
Page 89.
My lord, I have denied this document. This document has to be proven.
Maybe.
And that apart, even if I hypothetically assume that the document is of some, my lord, validity, the liability to pay is not of the company. It is of this individual who's signing and who's agreeing that he's the one who will pay.
On behalf of the company.
My lord, kindly, my lord, that's again, my lord, a tribal issue. This is the second tribal issue in the matter. My entire cross-examination, my lord, will be on two issues. And I'll just place those two issues. And then your lordship would, my lord, consider whether I should be depositing something or not, or whether I should not be alienating my assets, or whatever terms your lordship wants to put me to. First issue is that insofar as the claim of 46 lakhs of 2 months rent with GST is concerned, whether they are entitled to that money, given the entire, my lord, history of this property and the fact that not a rupee has come in from the broker, from the lessee, and even the lease did not fructify. Can the broker have? This is one issue where he takes a U-turn, and from successful transaction he then says merely introduction. That's the language. This is one issue that has to be, my lord. And the second issue is that
So going through all this, if you deposit the amount, let the you
my lord, my lord, if my lord, I have a good case, if I have a genuine case, at the end of the day, my lord, who are they? They are a broker.
Now the genuine case only with regard to challenge of this settlement. Challenge of this settlement. Main issue.
So settlement is confined to 31 lakhs
31.
minus 10 lakhs admittedly paid.
Paid.
So 21 lakhs.
Correct.
Interest, of course, your lordship will, my lord, decide
That's
under section 34. So question is whether I have to deposit this 21 lakhs or not. My lord, to answer that question, my lord, whether how strong a case do I have? If I certainly I have some case. Your lordship will, my lord, agree that certainly there is some case. If there is some case, I should be allowed to defend subject to, my lord, some terms. But if I have a good case, then your lordship will. So now, my lord, we'll confine ourselves to, my lord, whether this is a good case or not. So, my lord, in that event, my lord, I just have two submissions. First, that this document itself is a document that I'm disputing. This settlement itself is a document that I'm disputing.
Correct.
So this document, my lord, has to be proven. B, this document is signed purportedly on behalf of the company by a gentleman who has a tainted history, who has colluded in another connected matter pertaining to the same property, which was prima facie stated by a court of law and which is even now pending adjudication. And based on that document, my lord, we were not even directed to deposit any, repay any money by the High Court.
So this 10 lakhs was paid by not from his personal fund.
This gentleman has paid. My lord, kindly see clause 1.3.
Not from the Murarka, it is from the company account.
This, my lord, I will have to take instructions. I'll just clarify. It has been paid from the company's account, but this gentleman was the signing authority. And when, my lord, that MOU came to light.
If it is signing authority and it is paying the account and he had the knowledge in 2022.
No, my lord, may I just clarify that, my lord, this money that has gone from the company's account, this gentleman since when the MOU came to light and all these things, my lord, happened, my lord, he has been asked to, my lord, he's shown the door. So, my lord, I have those documents also, his resignation, and, my lord, all in this time, 2023, when this suit was filed, when the other suit was filed by the Guptas, that is, my lord, when all these documents came to light, that, my lord, he's been sacked. And I have those documents also to place. So, my lord, this document, whether at all it's a valid document, they'll have to prove this in trial, number one. Number two, my lord, the interpretation of clause 1.3. Based on this clause, whether, my lord, the liability is an outright liability of the company or whether it is a contingent liability subject to a particular individual within the company who's been acknowledged as the signatory and who's being referred to as a party in his individual capacity in this clause. Kindly, my lord, see the clause. Subconscious, my lord, often comes to light in writing.
Okay. Being one of the director of the Sunshine, I agreed to fund.
The first party being one of the directors. So the first party is being referred to as the director of a company. Not that the company is a party.
But the first party is the BP Suraj.
Well, defined, I agree.
Correct.
That in the definition.
The first party being one of the director of the BP Suraj. BP Suraj is the first party, so he's one of the director.
The first party being one of the direct. Well, it's on, my lord, wordplay. It's on wordplay. So, my lord, this particular director, and kindly read further, my lord, has agreed to fund and or provide necessary fund equivalent to the consideration amount towards the settlement.
Correct.
So a precondition for this settlement is for this particular human who is the signatory to bring in money for this money to be paid to the other party. So he should have been a party to the suit. Because in other words, let me put it this way. What my contention is that in other words, if this gentleman doesn't bring in the money, because it's his personal liability which he wants to set right. So if he doesn't bring in the money, then there's no obligation to pay. So it's a contingent payment. So long as this particular gentleman who's signing, the signatory himself, is bringing in the money. So this is the other issue. Now this, my lord, your lordship would, my lord, consider thinking.
File the affidavit.
Sorry, my lord.
File the affidavit of this application.
Yes, yeah, opposition. Yes, my lord.
Have you taken that non-joiner party?
My lord. In the written statement, it was a point, but then the written statement did not come on.
Maybe, but
Yes,
even
yeah.
though
Yes, yes.
argument can be the law point, you can take any time.
Just one moment, my lord. Yes, kindly see paragraph 3. There is a saving grace, my lord.
Yes. Non-joiner, yes.
Yes, it's. So, my lord, the entire settlement proceeds on a precondition that this particular signatory who is purporting to represent the company will be the source of these funds. And this has been signed and acknowledged by, my lord, the plaintiff itself. Now, whether, my lord, they are entitled to money, irrespective of this person's conduct, and whether he, being the signatory, brings this money to the table or not, is another triable issue. So, my lord, let this be tried. I am not somebody who's running away. I have a land worth 20 crores in Calcutta. I have constructed a building of 5 floors on that land. I'm not a fly-by-the-night operator. Not that, my lord, I'll vanish. And if they succeed in a suit, then I won't be able to, my lord, pay them off. This in any way event is not an injunction application. If they were suspecting that I will run away, they would have filed an application for, my lord, for injunction or for attachment, but they have not done that. They, my lord, want a summary decree. These are two, my lord, tribal issues which your lordship will consider. Because, my lord, may I just point out that there is correspondence exchange between the parties which has been placed all through these years, 19, 20, 21. But until 2023, when, my lord, the suit was filed by the Guptas for specific performance, that was a sign that this deal will never work out. Even today, my lord, 15 years, my lord, I am saying that for 5 years also, if they give me Kalyan Jewellers on this property, I will give them 2 months rent, not 15. 5 years, let them, my lord, bring Kalyan Jewellers for. And so long as they complete 1 year, I'll pay off the broker immediately. After 1 year, my lord, if they go, I can't do anything. I can't have a tenant forever. But I have to get something to pay a broker. He's a broker. It's not a fee, it's a brokerage. It's contingent upon rent being received.
Okay.
These are the two, my lord, primary issues. A, he's a broker. That point, my lord, is a good point. The other point, my lord, which I've had to perhaps, my lord, try to convince your lordship, is this, that the agreement, whether it's valid, and assuming it is valid, whether it is contingent upon this gentleman himself bringing in the money. And why is he not a party to the suit when it's signed that...
As per the submission, there are two issues you have raised.
Yes.
Whether without the full consideration of the without completion of the agreement between you and the Kalyan Jeweller, whether he is entitled to the amount which you have claimed,
Yes.
the broker's amount.
Yes.
Second, as per the settlement agreement, he has acted as a director, whether it is a personal capacity or as a...
Yes. And hypothetically assuming that it is not in his personal capacity, let's take a step further and assume, for the sake of argument, that this is on behalf of the company. Let's say I'm wrong. He had authority. He was an honest person. Even then, the clause says that it is contingent upon this particular person's signatory bringing in the money. So even if he's representing the company, assuming he's representing the company, whether the company is liable to pay, irrespective of whether this person pulls in the money. Because he's a signatory. Not that I'm naming a third person here. These are, my lord, issues which are to be tried.
Okay.
My lord, these are, my lord, I would say, my lord, not just, my lord, a plausible case, but a probable case, my lord. And I can cite Uptown if required, my lord. We all know that judgment. Not just a plausible case, but a probable case also, which warrants, my lord, unconditional leave to defend. And let him come, my lord. Let him come to the witness box.
Okay. That's all.
Nutshell, my lord.
ये फिक्स मैटर है क्या? फिक्स मैटर. Come next day. Fix.
Next week, may I get a chance, my lord, when we can complete? Next week, if I get a chance, my lord, we can complete. I don't want it to be fixed, my lord. I'll take my chance.
Okay, let. Record. Counsel for the defendant has concluded his argument in connection with GA2, na? GA2.
G2.
GA2 of 2025. Due to procedural time, plaintiff counsel for the plaintiff could not reply the same. Accordingly, case is adjourned. Let the matter appear. 23rd
Wait.
September.
My lord, I'm about yesterday, my lord, I'm sorry. That Supreme Court order that was shown, I read it, my lord. It was a mistake on my part. I'm very sorry. I didn't have the order with me, my lord.
Before
Matter is over. Hoga.
Wait.
Before Malad takes the next fixed matter. Item number 12.
Huh?
Item number 12, your lordship.
Huh?
Mr. Karnani is there appearing virtually. He's for the plaintiff. I am appearing on behalf of the defendants. So, on the last occasion, there was a direction upon us to complete the inspection and discovery. Accordingly, we have served a notice to the advocate on record, your lordship, on August as well as on September. But no reply has been made, your lordship. But
My lord, I shall be very candid before your lordship, my lord. Previously, my lord, we had offered inspection.
Let's count after some. Yes, after this.
my lord, great.
Item number 8. Yes.
Yes.
Lord, I was arguing, my lord, my section 8 application.
Yes.
I appear for the plaintiff. Attention.
Lord, we'll recall, my lord, agreement, my lord, between plaintiff, the defendant number 2,
Plaintiff, defendant number 2, 4
plaintiff,
and
defendant number 2,
4 and 6 are the
4 and 6, absolutely, my lord, 4 and 6, with regard to, my lord, their claim of, my lord, 18% shares in the shares which I'm going to acquire, my lord, in defendant number 1. Now, my lord, they file a suit now, say, and there's an arbitration agreement, my lord, quite naturally, my lord, in the 2012 agreement. Now they file a suit saying two things, my lord. They said I have an independent right still to acquire 18% shares, which is, my lord, nothing to do with me then. Secondly, he says that because I have not transferred him 18%, therefore he wants the consideration which is paid to me as well as, my lord, to defendant number 1, and also claims damages for not being able to get that 18%. That is, my lord, is paragraphs 32 and 34. My lord, with regard to his claim for, my lord, about 51 crores or something like that with profits and all that. Now, my lord, our contention is whatever rights he claims in the suit against me is only arising out of and can only arise out of the agreement of 2012.
Agreement of
2012. That's one of the original agreement. That's what he's suing on. That's what he's suing on. I don't want, my lord, I want to address GA1 a little later. Because, my lord, first, I think, my lord, GA2, my lord, is very important to show, my lord, because if section 8, my lord, is covered by arbitration, my lord, there's no question of, my lord, passing, my lord, any further orders here. So, my lord, so I am saying, my lord, if the plaintiff case or, my lord, the plaintiff's case against me is only through the agreement, which it has to be, because, my lord, he only has a right, my lord, with regard to the 18% shares, so under that agreement. Then, my lord, irrespective of whether, my lord, he's added others as a party or not, the suit, my lord, will have to be referred to arbitration. Okay. And this is, my lord, in terms of section 8. My lord, will see, my lord, will recall, my lord, the change in law in section 8. My lord, Sukanya Holdings, so, my lord, they have not relied upon. At one point said that if there were other parties, then you cannot refer it to arbitration. Okay. Then, my lord, this is what section 8 says. my lord, of the Arbitration Act.
Give the Arbitration Act. though.
And that's why, my lord, it was amended. And particularly, my lord, keeping in view, because, my lord, the encouragement is, my lord, to arbitration. Because the parties have agreed.
Yes.
A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through under him so applies not later
Then the date of
than
meeting first.
than the date of submitting his first statement on the substantive dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists.
Yes.
So today, my lord, the only test is whether there is a valid arbitration agreement or not. If, my lord, there is a valid arbitration agreement which covers the
Yes.
subject matter of relief against
The defendant.
the defendant, who is a party, my lord, to the arbitration, then, my lord, it has to be referred to arbitration. And, my lord, there is no dispute that, my lord, there is an agreement. There is no dispute that, my lord, there is an arbitration agreement. And, my lord, just kindly, my lord, let's
Who are
just
the
one.
parties to the agreement. All parties.
No, my lord, that's why I showed, my lord, parties. Plaintiff, different number 2, different number 4, and different number 6. They are the ones. Now, kindly, my lord, just look at, my lord, page 80.
18 of
80,
agreement.
my lord, of the, I'm sorry, my lord, the plaint, my lord, because our application, my lord, is not, plaint was given later.
What you want to refer the agreement?
Yes, my lord. I'm not the application
Yes.
annex.
Yeah, application you are annexed the original.
Yes, yes, my lord, we have annexed it, my lord, at page. MOU to annex page 30. Plaint nahi kintu. My lord, we'll also need to have a look at the plaint. So, my lord, page 13, my lord, is the MOU.
Yes. Clause 11.
Yes, my lord. At
And it-
page, my lord, 18 of, my lord, the application. Any dispute arising out of or in connection with this memorandum between the transferor and the transferee, including a dispute regarding the existence or validity or termination of this memorandum or the consequence of nullity, shall be referred to and finally resolved by arbitration of such person or persons as may mutually be appointed by transfer and transferee. Arbitration shall be conducted in accordance with arbitration, all proceedings and such. So, any disputes arising out of or in connection with this memorandum.
Correct.
Now, my lord, this clause has been defined, my lord, with Renu Sagar. My lord, the Renu Sagar judgment, my lord, 88th Supreme Court, we are not carrying a copy, my lord, carry a copy, but my lord is aware of it. My lord, this clause, my lord, is considered to be of the widest amplitude.
Yes.
Because, my lord, will remember, my lord, before section 16 of the Act, there was an issue as to whether the arbitrator can himself decide the existence or validity of the arbitration agreement or not. Renu Sagar, my lord, interpreted such a clause and say within its ambit, because it is so wide, that issue can also be decided. And this, my lord, before the 1996 Act itself.
Correct.
So that's, my lord, how, my lord, it was construed as saying it's a very widely worded. And, my lord, kindly also take, my lord, the page 15, clause 1, because this is an agreement to assign.
Yes.
How much, my lord, it is enforceable, how much, my lord, it was damages will arise out of it, my lord, that's a different issue. But, my lord, we are not on merits now. Kindly see, my lord, clause 1, page 15. The transferor has agreed, transferor, my lord, is me, has agreed to assign. So it's an agreement to assign, not, my lord, the assignment itself. And transfer its rights and benefits of its contract with the present shareholder under the share purchase agreement to the transferee, to the extent transferee, my lord, is the plaintiff, to the extent and to the effect that the transferee shall acquire out of the proposed transferor's allocated shareholding 18% of the total equity shares of the company held by the present shareholders, and the transferee is agreed to acquire the same at or for the consideration and on the terms and conditions hereinafter contained. Then we'll have to effectuate such transfer and such assignment transfer clause 2, transfer agreed to cause to be transferred with the above named present shareholders out of its proposed allocated shareholding agreed to be purchased by the transferor from the present shareholding under in terms of share purchase agreement. 18% of total equity shares of the company held by the present shareholders directly in favor of transferee by nominating the transferee to the present shareholders to complete the transfer of such shareholding. Present shareholder, the company in his favor. Now, my lord, then the consideration it says, just kindly let me read the clause 3. Consideration payable by the transferee to the transfer for such assignment and transfer has been agreed to be 14.76, out of which only 3.60 crores shall be towards the consideration for purchase of 18% total equity shares of the company, and the balance sum of 11.16 shall be towards 18% total loan amount agreed to be provided to the company under in terms of the said share purchase agreement. Why, my lord, I read clause 3 is, my lord, the payment which he makes, which he claims, because I, my lord, have to look at the plain, we have to look at the plain. Payment which he makes is only in terms of this agreement.
But in the agreement, who are the party? Plaintiff, Orbit,
Plaintiff, different number 2,
different number 2,
different number 4, and different number 6.
in this memorandum.
Yes, my lord.
Acha, Jagriti.
My lord, him and me are the main parties.
Yes.
My lord, see, memorandum means Jagriti, my lord, is the plaintiff.
Correct. And Tirupati.
Sorry, my lord, Jagriti is me. I'm so sorry.
Is,
Different number
2.
Then
And plaintiff is the Tirupati.
Tirupati is plaintiff.
First party.
Yes. Who's the transferee? I'm the transferor.
Correct.
And second part, and Orbitas Private Limited and Damani Infracon confirming parties.
Orbit. They are the confirming parties.
Because, my lord, recalls, my lord, under the main agreement,
4 and 6.
all three of us, which is, my lord, the Jagriti, Orbit, and Damani, were to acquire 100% shares of, my lord, different number 1.
Correct.
I was to get 36%.
And
So arrangement was, my lord, he will get 18% under this agreement. It's an agreement to assign, not an assignment agreement, where, my lord, can be enforced clauses and all that. That's on merits. I don't want to go into that. But what we are on, my lord, so any right, and this is very important, my lord, any right which he claims, the plaintiff, can only be in and in terms of this agreement. And so making non-parties party to a suit, and I'll show, my lord, judgments on that, will not defeat the right which he claims against me. Because then, my lord, it will be very easy, my lord. I file a suit, my lord, against my learned friend.
So what about the other defendants?
Not relevant for this purpose.
What is we have prayed for in the suit?
Yes, kindly look at, my lord, in the plaint. Now, my lord, kindly look at the plaint. No, there's a copy. Oh, no? Plaint to that. Better not to disclose the plaint for them.
Award dated so.
Physically, 27th.
Yeah.
But I'd like to show a few paragraphs, my lord. My lord, paragraph 3, my lord, must have, I don't know whether my lord has already, my lord, glanced through it. Page 5, my lord, paragraph 3.
Yes, taken note of. Yes.
3B, my lord, talks about the other agreement, 24th March 2011. Then, my lord, kindly come to paragraph 4. Is, my lord, the present memorandum of understanding. And then, my lord, kindly see, paragraph 4 is very important, relying on the representation made by the different numbers 3, 5, and 7. And 3, 5, and 7, my lord, are the directors of different numbers 2, 4, and 6. Okay. And I will show what is the averment, my lord, with regard to 3, 5, and 7. The plaintiff agreed to purchase and or acquire 18% of the total issued, subscribed, and paid up share capital equity shares different number 1 for the consideration rupees 14.72 crores. Then, my lord, can you see? And on the terms and conditions mutually agreed between the parties sometime in January 2012. This is, my lord, what we are concerned with. It was further agreed, agreement arrived at by and between parties would be recorded in a memorandum of understanding. Then, my lord, 5, 6, my lord, he talks about his payments being made. Then, my lord, paragraph 8. Pursuant to the agreement of January 12, the plaintiff and the different numbers 2, 4, and 6 executed a memorandum of understanding dated 21st June 2012, which is, my lord, that memorandum which I showed. Whereof the plaintiff different number 2 agreed to assign on a sell or transfer the 18% of the total issued, subscribed, and paid up share capital of the different number 1 being 50% total equity shares, so acquired, the ceremony was executed. Then, my lord, paragraph 9 clauses set out. My lord, we can skip over all that. Then, interestingly, my lord, kindly come to page 12. My lord, sees he sets out all clauses. My lord, page 8, page 9, page 10, my lord, will see he's setting out all the clauses. And now kindly come to, my lord, page 12. Clause 10, page 12, my lord.
Yes.
He's setting out.
Transfer is thereby agreed to purchase.
Clause 10 he sets out, and then he misses out clause 11. Clause 11, my lord, is the arbitration agreement. Then, my lord, he sets clause 12. All the clauses, my lord, he sets out. From page 8, my lord, all the clauses he set out.
Yes.
And he sets out 10, my lord, misses out on 11, my lord, and quickly comes to 12.
Yes.
So I'm just saying, my lord, it's a very material clause, because 11, my lord, is the arbitration agreement which he has to deal with. I my lord, understand, my lord, he deals with it, but he's not, my lord, said anything, misses out, my lord, on clause 11, doesn't set it out, which is, my lord, a deliberate suppression. Then payments made prior to execution of said MOU were treated as payments. This is very important. Payments made prior to execution of the said MOU were treated as
made in terms of the MOU.
Yes. Said recorded in the said MOU, save and accept payment of 1 crore 88, which was paid to the number 2 by check dated sunset and made payments from the register office. Then, my lord, paragraph 10, 11, my lord, it's in the course of, according to him, my lord, these are all on merits. I'm not troubling, my lord, with all these paragraphs. Then, my lord, will kindly come to paragraph 13 again, my lord. I'm sorry, my lord, I don't want to, but there are a lot of incorrect statements, but we are not on that now, because he was quite aware of everything. 13, 14, my lord, he talks about the development agreement. So he's aware of everything. He sits on the side. Then, my lord, 15, my lord, he says he makes payment. Then kindly come to straight away, where, my lord, he says that, my lord, he is a alter ego. I'll just, my lord, give, my lord, the yes. Alter ego. My lord, sorry, my lord, paragraph 19 is very interesting, because, my lord, this is directly contrary to what has, my lord, been found, my lord, in the arbitration. Because, my lord, in the arbitration, my lord, I said, my lord, 100%. My lord, I had made payment of, my lord, according to me, 100% of the whatever I had to pay. According to the plaintiff, borrowed some money from him as well. The arbitrators held that no, I had not paid 100%. Because there was another MOU of 24th March 2011. That is why, my lord, it was directed that whatever money I paid will be, my lord, paid back. That's, my lord, what the Honorable Supreme Court.
Whom?
To me.
No, with whom that agreement?
With them only. My lord, what happened? I produced a version of the agreement, which according to me was the correct agreement, where the consideration was lower.
Okay.
And they produced another agreement, where the consideration was higher. So they came and said, sorry, you give me more money. Court will know.
That is not.
Yes, that's the dispute there. Now, my lord, why I'm saying, so kindly see, my lord, paragraph 19. Because this is incorrect. My lord, either defendant number 1 was lying, my lord, in the arbitration, or my lord, the plaintiff is lying. Because it says plaintiff inquired of the defendant numbers 1, 3, 5, and 7 about the issuance of shares of defendant 1 in its favor, and the distribution of profits as construction of the new building was nearing completion. Defendant numbers 1, 3, 5, and 7 assured the plaintiff that the shares would be allotted to in terms of the said MU, and it would receive share of profits in the form of dividend proportionate to shareholding once sublease of all units have been completed. Plaintiff bona fide believed and relied on such assurance. So he ropes in 1 as well.
Yes.
Now 1, of course, ran a contrary case in the arbitration. So that's why I said, either the plaintiff is correct or the defendant 1. So one of them is lying. So we are not concerned with it. Then 20 is very important also. Sometime in July 2024, plaintiff was surprised to receive a notice from the Learned Mediation Center against the plaintiff. Defendant must choose copy of the notice and such. This was a suit filed by defendant number 1. Saying that the award is binding on him also. Directly contrary to prayer A in this suit. Then receipt of such. Then, and that's why I said he's aware of it from July 2024. He takes no steps, doesn't go to the Supreme Court as well. He knows he would have been thrown out. Then 22, on the mediation. Then 23, is his knowledge with regard to the other arbitral proceedings. Then his email dated 11 September 2024. So we are 1 year down the line really, Then copy of the plaint, paragraph 25 he receives. Now this will be all relevant when I argue the interim order GA1. I'm not doing that now. Now kindly see in 28 he pleads fraud. Now nowadays now the present law is even fraud doesn't take it away from the arbitration proceeding. Even fraud is covered.
Yes.
Because that judgment in our that judgment was Maestro engineering. That was this is the Supreme Court judgment. That was not. It was held to be not good law. Then 29 is important.
What about the allegation of the fraud now?
Fraud, fraud is also to be decided by the arbitrator if that at all there is a question of fraud being pleaded. So that's what I'm saying. It's not no longer a question of taking away the jurisdiction, because if that's what they have not submitted yet. I don't know what they want to submit on the section 8. But my submission is that even questions of fraud can be decided.
Yes.
By the arbitrators, though I can show in the face of it, the fraud is really not relevant, because what he claims is money arising out of the shares or non giving him the shares in terms of the agreement itself. So that's the link. Then 29, kindly look at 29 is important. At all material times, defendant number 1 was the alter ego.
Yes.
Of defendant numbers 8 to 19. So 1 and 8 to 19 are the same party according to them. Defendant number 8 to 19 functions to the instrumentality of the defendant numbers 1. Defendant number 8 to 19 are the main decision maker of defendant number 1. Corporate veil of defendant is lifted. It would be evident defendant numbers 8 to 19 mind behind the acts of fraud perpetrated with answers. Then 30 says defendant number 2 is the alter ego of defendant number 3.
Yes.
Which means the company is according to them,
yes,
the alter ego of the director. Now I am showing all this just to show that the parties are really limited. Just because you make directors a party doesn't mean you come and argue that now there are other parties, therefore you can't refer me to arbitration. Then Mullah, this is paragraph 30 is all on Mullah the question of different number 2. Then Mullah, kindly come to the next page. And kindly Mullah, note this paragraph, Mullah, paragraph 29, 30 and 31. Very important because all the directors they say are alter ego.
Yes.
The company is the alter ego of the director. So quite naturally, they're not required parties.
Yes.
Page 22, Mullah, says different number 4 is the alter ego of the different number 5.
Yes.
Now 4 is a party to the arbitration agreement. So you yourself say that 4 is the alter ego of the different number 5. At the top, Mullah, page 22 at the top.
Yes.
And then again, Mullah, sees paragraph 31. 6 is the alter ego of the different number 7. Now again, 6 is a party.
Yes.
So I am showing in the suit, unnecessary parties have also been made parties.
Yes.
To try, Mullah, and defeat the arbitration agreement and Mullah, the crux of the matter.
Yes.
Then Mullah, now kindly come to paragraph 32, Mullah, which is one of their claim, very important, page 23.
Yes.
You were never present.
May I will also sleep for a minute.
Neither binding nor
Yes.
affect the right of the entitled.
As the defendant have failed and refused to transfer 18% shares of in the defendant 1, Mullah, paragraph 32. Plaintiff is, so Mullah, the causes 18% I have not transferred, entitled on claims payment of 11 crore 24, being the aggregate amount paid by it as consideration for acquiring such shares. Plaintiff is entitled claims interest 12%, which on 12th May 2020 aggregates to 15 crore 68.
Yes. There's a prayer B.
That's right. Absolutely. I'm so grateful. Correct. Absolutely.
Yes. Then
Mullah, paragraph 33, suffered loss and damages by reason of the defendant's failure or refusal to transfer 18% shares. Stated. Then Mullah, 34 is the next prayer.
34 is a C prayer.
Plaintiff said purpose of acquiring the shares of defendant 1 was to exploit the leasehold right of the defendant 1 said premises by constructing a new building. Shareholder defendant number 1, the plaintiff would have earned profit from sublease of the new building.
So they are damage.
Yes. And arising out of Mullah, same
Contract.
non-transfer of the 18% share. Now, absurd claims, but Mullah, I'm sorry, we are not on merits now.
Yes.
It was an agreement to assign. An agreement to enter into an agreement, Mullah, is never enforceable. Then Mullah, different 14 from certified copy registered deed, it transferred, different giving long-term sublease. Then Mullah, they calculate the square feet and they say 18% shares, Mullah, according to them, 18% would have been 25 crore.
Yes.
Now, quite naturally, Mullah, I have not got all this, Mullah, in the other award. I've been only given back, Mullah, my principal and what he claims he is given to me, Mullah, without any interest. Now, Mullah, so 32 and 34 and 34, Mullah, is prayer C. Now, Mullah, 35 is very important. These damages have arisen in the natural course of things from the defendant's breach and defendant knew and were aware that the plaintiff would suffer such damages, Mullah, when they entered into the contract with the plaintiff.
And received consideration. So, basing upon the memory.
And received consideration from the plaintiff for transfer of shares in favor of the plaintiff. Directly relatable to the contract itself.
Yes.
And then 36, Mullah, he adds up, Mullah, those two sums. 37, Mullah, is the alternate claim.
Yes.
Then, Mullah, 38
Alternative.
is, Mullah, the deposit, Mullah, which was made, Mullah, by the different number 1 with the original side, Mullah, registrar when, Mullah, they challenged the award. All this was, my lord, last year in July and August 2024.
Yes.
Then, my lord, 40. He, my lord, makes a point, my lord, with regard to all parties being joined, my lord, because there's collusion and conspiracy, my lord, between the parties. Then, page 27, that apart, present all that is necessary for normal, complete and effectually adjudicate and settle on questions involved in the suit. Then 41, matter of commercial. Then
What is your submission to the 40?
My lord, doesn't matter. It doesn't matter for this reason, because you cannot defeat an arbitration claim. Arbitration, that's it.
Yes.
And this is not like, my lord, section 8 is not like, my lord, in order 7, rule 11. You may say whatever you want to say in the plaint. It is not an order 7, rule 11. I'm not asking for dismissal of your suit.
Referring.
That's right. So, my lord will look into, my lord, what is really, the court will look into, my lord, as to, my lord, first, whether there's an arbitration agreement. Second, whether the reliefs claimed against the party applying for reference are covered by the subject matter of the arbitration or not. And, my lord, the suit will have to be referred. So, we are not, my lord, on the question of subject matter of, my lord, that suit in its entirety, but, my lord, whether the reliefs claim. That's why I showed, my lord, B and C are directly relatable. And only, my lord, under the arbitration clause
Because
of, my lord, the 20.
Coming out from the MOU.
That's right. And that's what they say. So on this, yes, my lord, on this basis, my lord, they, my lord, make the prayer. And then, my lord, 45 is also important. Subject matter of the SPA and the MOU shares of the defendant.
That's the cause of X.
Correct. Again, my lord, arising out of the MOU.
Yes.
So SPA and the MOU.
Yes.
That's his cause of action.
Yes.
And very interesting, my lord. In the entire suit, he does not say how, my lord, the arbitration agreement is not applicable. And in fact, my lord, he suppresses the arbitration agreement.
In one paragraph is stated.
Sorry, my lord.
In one paragraph he stated only some word.
I must have missed it, my lord. I'm sorry, my lord, on the arbitration.
Yes.
Okay. What was he said out? I'm sorry, my lord. I must have missed it then. No. The arbitral proceeding, my lord, they talk about is the other arbitral proceedings.
Yes.
The other, my lord, not this one.
Correct.
Not the arbitration agreement here.
Yes.
I don't know, my lord, whether, my lord, wants to, my lord, look at page 23. Is that perhaps, my lord, before in paragraph part of paragraph 31? I don't know, my lord, whether, my lord, is referring to that one.
Yes.
Sorry, my lord, subject to, my lord, correction, my lord, I did not find, my lord, any reference, my lord, to this arbitration agreement, my lord. In fact, my lord, I found it, my lord, they've skipped it, my lord, in their setting out the clauses.
Setting out clauses, yes.
Yes.
Yes, next.
Not, my lord, not said. Not said.
Yes.
The only thing, my lord, they put in the paragraph, my lord, is that saying that why they have in terms of civil procedure code, the joinder of parties. Not, my lord, on the arbitration.
Paragraph 40.
Yes.
Yes.
That's, my lord, with regard to joinder.
Joinder.
Because you have added, my lord, all these parties. Because according to me, my lord, as soon as, my lord, will recall on the last occasion, I'm sorry, I'm just troubling, my lord, with that other, my lord, where he says he has an independent right, my lord, page 23 again. just before just before paragraph 32. Kindly see defendants instituted arbitration behind the back of the plaintiff, so each of them knew that 18% total share of defendant has been
That you
assigned.
pointed out.
Yes, an independent right.
It was an independent
That,
right over
so to have that joinder of cause of action, because you can't have both independent right
and
and correct. Correct.
yes.
Now, Malad will kindly take. Okay. Eastern. Correct. No, Malad, sorry, Malad, my Mr. Shoka was just pointing on Malad. In the written statement which they filed, Malad, in the defendant number 1 suit, they are also, Malad, the same stand has been taken with regard to Malad, saying that Malad, they are going to get the shares, Malad, because they've given the money. Judgment. Now, Malad, kindly look at. So, Lindsay, এটা আছে তো সুপ্রিম কোর্টটা আছে তো Lindsay আগে দাও Malad, this was a single bench, but Malad affirmed, or rather, Malad, the SLP was আমার কাছে কিন্তু সুপ্রিম কোর্টটা নেই. Where is the Supreme Court? Sorry, just give me one. Lindsay, Supreme Court. I'm sorry, just give me 1 minute. Where is the Supreme Court? Anyway, Malad, may I just start showing Malad this? Give a copy to the others and give one to me. Copy, Doctor. Just take it out. Report it. What the reference? Report went up to the Supreme Court. To me, better prepared than all this. Malad, kindly look at Malad paragraph 6 here. Malad, this was suit filed. Paragraph 6, Mr. Sansach appearing for the. So, sorry, Malad, may I just show Malad paragraph 4 first at page 2? SCC sorry, Malad, we should have got Malad the SCC online reference. That would may have been better. If my learned friend had. Very well, then Malad, paragraph 4, Malad. Lindsay has filed a suit for decree for specific performance of pre-incorporation agreement against the defendant 1 to 38 and for specific non-compete agreement against the defendants 13 and 42 and for declaration injunction. The applicants IFGL refracted defendant 41 and 42 in the suit want all claims, disputes and differences made by the plaintiff number 1 Lindsay against IFGL, which are the subject matter of the suit, to be referred to arbitration in terms of the arbitration agreement contained in purchase orders issued by Lindsay upon IFGL. Applicants also pray for stay of all further proceeding in the suit as against the applicants IFGL. Arbitration clause refers to IFGL as the seller and Lindsay as the buyer and covers any dispute, controversy of interpretation of any terms or claims arising out of or in connection with the purchase orders. Then Lord 6 Malad sees Mr. Sansach, learned senior counsel appearing for the plaintiff, opposes the reference on the ground that the dispute against the different defendants are inextricably interlinked. This Malad the opposition and are incapable of piecemeal adjudication. Counsel submits that the relief paid for by IFGL are geared to bifurcate composite cause of action and split necessary and proper parties. It is submitted the disputes forming the subject matter of the suit are not covered by the arbitration agreement and do not arise of the limited scope of the purchase orders to which the arbitration agreement relates. Counsel places reliance on Sukanya Holdings and on the recent pronouncement of the Supreme Court in Vidya Drolia versus Durga Trading Corporation in support of this contention. Then Lord 7, upon considering the submission made on behalf of the parties and the relevant materials on the question to be answered, this court proposes to structure the judgment in the following manner. A, the import of Section 8 post amendment. B, case made in the plaint against the applicants defendant numbers 41 to 42. C, whether the cause of action can be bifurcated. D, relevance of Sukanna holdings at the stage of reference. Then my lord, paragraph 8, 9, then kindly come to 9, my lord, is important also. From a plain reading of the provision, section 8.1 mandates a judicial authority before which an action is brought to refer a matter which is the subject of matter of an arbitration agreement to arbitration. If the existence of the arbitration agreement is admitted, all that the court is required to look into is whether the matter which is going to be referred to arbitration has a valid, this is very important, has a valid arbitration agreement. Statutory mandate is subject to the court ascertaining whether any valid arbitration agreement exists, whether the matter is arbitrable, whether the party who seeks reference has applied before submitting his first statement on the subject matter of the dispute. If the court can take all the above conditions, court must refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Then what section 8 is set out. Then what 11. The unambiguous mandate on the court is to refer the parties to arbitration regardless of any judgment, decree or order of the Supreme Court or any court. The only exception that the court can make to the above is if and only if it is prima facie established that no valid arbitration agreement exists. The onus of establishing that the valid arbitration clause does not exist rests squarely on the party who seeks to resist the reference. In terms of semantics per se, from a reading of section 8.1, it is evident clause, unless it finds that prima facie no valid arbitration agreement exists, is conditionally nested under the mother clause, notwithstanding any judgment, decree or order of the Supreme Court or any court refer the parties to arbitration. Hence, it is crystal clear that if a valid arbitration agreement exists, court must refer the parties to arbitration, even if their judgments, decrees or orders of the Honorable Supreme Court or any other court pronounced before 2016. Then, my lord, we can come to paragraph 14. With the 13, the learned judge looks into what was the law commission report. Then 14, with reference to the above, a reckoner of what was proposed and what finally was written, stroke rejected or inserted deholds the recommendation in the amendment to section 8 may be easier to appreciate from the statement below. Parts in bold in column 2 are what was supposed by the law commission, and parts in bold in column 3 are what was inserted in section 8.1 post amendment. Then my lord, column 3, my lord can see to the arbitration claiming from under him. Then my lord, next page, page 8. Then notwithstanding any judgment, decree or order of the Supreme Court, unless find that prima facie no such. Then my lord, paragraph 15, my lord, the objects and reasons are there. My lord, we can just skip over my lord, those paragraphs. We can come back, my lord, if required later. Then my lord, paragraph 16, Sukanna.
Recent.
Yes, my lord, Sukanna and Amit Lalchan, my lord, are considered. Then MR, MGF, my lord, is considered. Then kindly come to paragraph 17. 17.
NN Global.
Another, yes, my lord, NN Global, my lord, recalls, my lord, that also, my lord, is considered. Then, my lord, kindly come to paragraph 18 is a little important. Although the plaintiffs have relied on Vidya Jolie and parts of Hero Electric to urge that the Supreme Court has called for a centralized adjudication of disputes where the disputes are interlinked with each other and the cause of action cannot be bifurcated, the said contention has to be seen in the proper perspective. Paragraph 28 of Vidya Jolie refers to the dictum in Sukanna Holdings and instances where such dictum would apply, but does not say that the Sukanna Holding is still good law and would cover all instances where a party applies for reference of the dispute to arbitration. This would be clear from para 154, court not to enter into mini trial so as to use up the jurisdiction of arbitral tribunal, and para 159, where the Supreme Court leaves the issue of arbitrability to be decided by the arbitral tribunal. Vidya Jolie hence cannot be cited only for the proposition that a centralized adjudication is the preferred route in all cases. Further, Vidya Jolie has to be seen against the other pronouncement of the Supreme Court in MR MGF, NN Global, which reinforce the legislative intention of minimizing judicial interference in matters of reference. Pointers set out in paragraph 41 of Electric, which the plaintiff have relied upon, are in the context of arbitrability and in rem disputes. 19. The only conclusion which emerges from the above interpretation and decisions is this: a court must keep a hands-off approach as opposed to a face-off with the arbitration process and give a decisive push to the arbitral process once the court is satisfied prima facie that a valid arbitration agreement exists in a matter which is arbitrable. Court's inquiry is limited only to this and no more. Because here, Mullah, that's why I'm saying, Mullah, the dispute or the release which they claim, our prima facie I'm showing, Mullah, is covered. And Mullah, existence of arbitration agreement, Mullah, is also not denied by them. Then B, the case made out against the applicants defendant numbers 41 and 42, IFGL would appear from paragraph 42 onwards. Paragraph 42, the plaintiffs have pleaded a negative covenant incorporating the agreements between plaintiff number 1 and defendant numbers 41 and 42, by implication to the effect that the defendant 41 42 would not enter into competition with the plaintiff company by selling its materials to any of the ArcelorMittal companies. Paragraph 45 pleads breach of contract on part of the defendants 41 42 and also sets out the entire cause of action against the said defendants. Paragraph 45E admits that applicants under Section 9 of the Act were filed by the defendant numbers 41 42 for various injunctive relief against plaintiff company. Paragraph 45GG alleges breach of contract by the defendants 41 42. Paragraph 51 alleges loss and damages suffered by the plaintiff company on account of repudiation of the non-competition agreement by the defendant numbers 41 42. Reliefs claimed against 41 42 are in paragraph 64 and 65 plaint, namely the said defendants are liable to pay substantial damages to the plaintiff company. Other relevant paragraph would be paragraph 12 of the plaint, which refers to the purchase orders issued by the plaintiff company to the defendants 41 and 42. Well, recall, Mala, this is an application made by 41 42 and state the defendants 41 42 along with defendant number 39 simply acted as suppliers vendors of plaintiff company without having any contractual privity with any of the Mittal companies. Paragraph 29 also states defendant numbers 39 to 42 were amongst 4 of the existing suppliers vendors used by the plaintiffs to supply refractory materials, other allied goods to the Mittal companies. Paragraph 41 pleads an oral agreement with each of the defendants 39 and 42, states that apart from the express stipulation which were essential, fundamental terms agreed upon between the plaintiff company and said for defense, certain general terms and conditions were also mutually agreed upon, which were routinely followed by the plaintiff company while purchasing the said defendants. Moreover, the allegation paragraph 50 of the plaint, then Malad kindly see, moreover, the allegation paragraph 50 of the plaint in relation to procurement or breach of contract is against defendant numbers
1 to 38.
1 to 38.
And not against the defendant number 38.
So, Mullah, there also, Mullah, it was a question of Mullah saying that these are parties, they have procured breach of contract, and these are the ones which are purchase orders. So, Mullah, they also added paragraph parties 1 to 38, and not against defendant numbers 39 42, the vendor defendants. There was no case of procurement breach has been made out against the vendor defendants in the plaint. Allegations contained in paragraph 45, 2 of the plaint with reference to defendant numbers 1 to 42, acting in collusion and conspiracy with each other to deny the rights of the particular, lacks the particulars required for pleading such nature under Order 6, Rule 4 of the Code of Civil Procedure. Then 41 statement do not plead or reject any collusion conspiracy between 41 for other vendors. Then Mullah, kindly come to paragraph 24.
Yes.
It is thus evident from the statements made in the plaint that the suit has been filed against 2 groups of defendants with separate claims and cause of action, which has been claimed and pleaded against each of the said groups. More particularly, A, the Mittal group consisting of defendants 1 to 38, to who the plaintiff number 1 was selling goods, and B, the vendors group, defendant numbers 39 to 42, from who the plaintiff company was buying goods. So now, Mullah, kindly correlate, Mullah, with an independent right.
And the
Yes. And Mullah, the right against me with regard to the 18%.
directly through the agreement.
Then Mullah, C, very important, can the cause of action in the suit be bifurcated? Order 2, Rule 6 of the Code of Civil Procedure gives an option to the court to order separate trials where there is joinder of cause of action in one suit, which has a potential of delaying the trial or otherwise cause inconvenience to the proceedings. Now, Mullah, kindly look at this. Because here also, Mullah, I'm saying, that's why I said, Mullah, independent right, it's, Mullah can always say, I'm sorry, these are 2 different cause of action which you're pleading.
Joinder cause of action is one.
The aforesaid provision then provides for cases where bifurcation separate trials are called for by reason of joinder of cause of action and parties. As discussed in the preceding section of this judgment, reliefs claimed against the 2 groups of defendants, namely the Mittal group and the vendors group, of which the applicant, defendant numbers 41 and 42 are party, are separate and independent of each other. Disputes and reliefs claimed in the suit are hence bifurcable. It is also to be noted that the suit was filed after receipt of notice under Section 21 of 1996 Act for commencement of arbitral proceeding. Also relevant that existing validity of the non-competition agreement said to exist in Linz and Menzer. Then, my lord, 27 fairly assumed plaintiff has been prepared. It can fairly be assumed that the plaintiff has been prepared with the object of avoiding the arbitration agreement between plaintiff 1 and the vendor group of defendants. Then, my lord, 28, my lord, NN global is, my lord, considered. Then, my lord, kindly look at 29. Hence, this court does not find any merit in the argument made on behalf of the plaintiffs that the disputes, if referred, would result in bifurcation of composite cause of action or split up necessary and proper parties. This interpretation is in any event destructive of the legislative intent to promote arbitration as noticed in the earlier part of the judgment. The view of this court is bolstered by the fact that none of the decisions cited, including Vidya Drolia, have held that an application under Section 8 will only succeed if the entire suit is capable of being referred to arbitration. Then D is Sukarna holding relevant at the stage of reference post amendment. Recommendation of the Law Commission of discouraging reference where the parties to the action who are not the parties to arbitration agreement are necessary parties to the action read with note referring to Sukarna holding did not serve as a trailer in the final cut of the 2016 amendment. Legislature, in fact, jettisoned the entire portion on necessary parties as well as Sukarna holdings to declare with unequivocal intent that the judicial authority shall refer the parties to arbitration, notwithstanding any judgment, decree or order on Supreme Court or any court. The amended Section 8 hence does not contain any remnant of the recommendations with reference to Sukarna holdings and has thrown out any impediment in connection with the dictum in Sukarna holdings or any other judicial pronouncement before the amendment in its entirety. The dictum in Sukarna holdings that bifurcation of cause of action and parties cannot be permitted in adjudicating an application under Section 8 has been rejected in NN Global. See the preceding section of the judgment. I did not read that paragraph, but this is what it. Vidya Drolia also cannot be used as a proposition to support the plaintiff's argument that the entire cause of action in the suit must be capable of being referred to arbitration in a Section 8 application. In fact, paragraph 225 Vidya Drolia recognizes that judicial interference at the reference stage has been substantially curtailed and the 2015 amendment has altered the structure of the Act to make it pro-arbitration. Paragraph 154.3 of the said judgment further reinforces principle of severability, competence, and that the arbitral tribunal is the preferred first authority to determine all questions of non-arbitrability. In paragraph 244.4, advice of the Supreme Court is when in doubt, do refer. The conclusion without a doubt is that Sukarna holdings is no longer a relevant factor for the court to consider at the stage of reference in an application of Section 8 of the Act. Court is not even under a mandate post-amendment to adjudicate on the bifurcability of the cause of action or the presence of parties who are necessary parties to the action but not to the arbitration. The only break in the momentum of reference is the court finding prima facie that no valid arbitration agreement exists. There is no case on that at all. In fact, the arbitration agreement has been totally ignored by my learned friend, suppressed. The rejection, then 33, rejection of the Law Commission's recommendation, note to Section 8, consider MRMGF, where the Supreme Court opined, pronouncement made prior to the amendment not to be read to as the legislation was to move away from the contention. Anand and Sukarna holding, court proceeds to explain the objective amendment was to minimize scope of judicial authority to refuse reference to arbitration. Then, my lord, paragraph 35, court is of the view that adding to the plain and unambiguous words of the provision in the pretext of interpretation cannot be the permitted cause of action. Then, my lord, 36. It is also important to bear in mind the issue is not whether the dictum in Sukarna holding is correct, as the law laid down in the decision may continue to be relevant for deciding application under Section 8 filed prior to the amendment 2016, but not whether suit or application is filed after 23rd October 2015 when the amendment came into force, underlined for emphasis. Then, my lord, bar to reference amendments, the existence of valid arbitration agreement, that is, my lord, is considered. And my lord, paragraph 38, all the purchase orders contain the above arbitration clause. Here, my lord, there's only one agreement. It is also undisputed that the plaintiff company accepted the invoices of the applicants from the purchase order without demur. Plaintiffs have also not disputed
The
arbitration dispute or the existence of validity of the arbitration clause. Notably, the general terms and conditions supply data issued plaintiff Lindsay on the vendor defendant also contains an arbitration agreement. Arbitration clause record that terms shall remain valid for all purposes issued by Lindsay after 1st September under Lindsay unless Lindsay confirms to the seller vendor defendant modification term. Then, my lord, kindly look at 43. Sorry, 41.
Amit Lalchan.
In this context, reference may also be made to Amit Lalchan Shah, where the Supreme Court referred all the 4 agreements which form the subject matter of the suit to arbitration, although one of the agreements did not contain an arbitration clause on the ground that this particular agreement was connected with the others which had the arbitration clause. Then 43, in any event, question whether the contract with the vendor defendant intertwined with the contracts between plaintiff and Mittal's defendant matter of interpretation of contract regarding purchaser falls within domain of the arbitrator. Also relevant, the defendant 1 to 38 have not opposed the transaction for reference to arbitration. Then, my lord, paragraph 45. The present case squarely falls within the dictum of NN Global, not a list in rem, claim to exercise the right against the world at large. Claims and disputes are entirely between private parties for determination of their rights and obligations as contained in the purchase orders. Here, kindly read MOU containing the arbitration clause. Also not a case because of actions have no dispute requiring Senate or would have the effect of binding third parties. Piecemeal adjudication appropriate. Noted even for amendment. But validity of arbitration was admitted. Statutory mandate refer the parties to arbitration. Then, my lord, on this ground, my lord, 40. Okay. Lord, at page 26, paragraph 51 and 52, my lord, it gets referred to arbitration.
Yes.
And, my lord, this is, my lord, it went up, my lord, to the Supreme Court, my lord, and this is, my lord. Okay. I got a number.
Yes.
Well, the other judgments I'll refer to it, but just, my lord, on this judgment, my lord, 3 things, my lord, it seems, my lord, this is what, my lord, this according to me, my lord, the ratio. First, my lord, if there is an arbitration agreement between the parties who's asking for reference to arbitration and the other party who's the subject matter of the arbitration, then, my lord, if it exists,
Then it has to be
has to be referred.
parties to be.
Because the whole purpose is, my lord, then not to defeat the arbitration agreement. Because that, my lord, becomes infructuous. Today, it's party autonomy, my lord, which has been given, my lord, credence to by saying that if, my lord, his plaintiff and, my lord, I have agreed to an arbitration clause, and we are not on the merits, arbitration agreement, arbitration clause, with regard to, my lord, this subject matter, it will have to be, my lord, referred to arbitration. Now, by putting, my lord, other parties, and this is, my lord, what this judgment holds, where it's a separate cause of action, and this is, my lord, very important, where, my lord, the learned, my lord, learned judge, my lord, also says you have the power under CPC also to bifurcate.
Yes.
Order 6, my lord, permits. Order 6, my lord, permits bifurcation also.
Yes. Next.
So, therefore, no reason, my lord, why, my lord, it will not, my lord, going to. My lord, I believe, my lord, has another matter at 12:30, my lord. Can I stop, my lord? I also have another matter fixed, my lord.
Further,
My lord, I need, my lord, about, my lord, half an hour or 40 minutes
Sir.
maximum. Half an hour, my lord, but there are some more judgments, my lord, which I wanted to, my lord, rely upon.
the counsel for the defendant number 2 had argued the matter at length, but due to paucity of time, he could not complete it. Let the matter appear on after vacation. कब है? डेट है कुछ? कितना बजे? 7 November 11:30.
I think this side of the vacation. At least the section 8 could be concluded.
2nd November, my lord, is a
7th.
oh 7th. I'll be there.
Before there is no time.
Yes,
Section 8 could have been concluded, my lord. Only
take your time, guys. So that's an important, my lord, point, my lord. In fact, one of my other matters, my lord, I'm also, my lord, there. 7th November, kota সময়?
7 November. Come on.
11:30. Very
At 11:30.
11:30. সাত তো আমিও 2 শুনলাম, 2 হলো সানডে। I'm grateful.
Okay, thank
11:30, again over 9 and
11:30 না 12:30.
12:30, 9 and 10.
I'm grateful.
Thank you.
Lordship, I appear on behalf of the defendant, Repo Bank.
Yes.
My witness is cross-examination. The witness is present, please.
Rashmi Ranjan Mahapatra. Rashmi Ranjan Mahapatra. Today, right? Victor,
regarding R42 or money of 59 crores coming in after banking hours, did the zonal manager, the zonal head, while Mr. Ki Samantre, zonal head, Mr. What's his name? Samantre, na? Mr. Samantre, who affirmed the suit, Samantre, who affirmed the suit in March/April 2013, at all referred to these at all referred to these circulars like R41 or R42 or money coming in after banking hours. Just show him the plaintiff. You can see the plaint filed by UCO Bank.
Space. Page number. This is the plaint, sir. He's asking for the page number.
The entire plaint. Did he at all refer to all this R42 and R41 or banking hours at all in the plaint? The zonal head. It's a 14-page plaint only.
The plaint. My lord, I have to go through every, and this is voluminous one.
What I go through? Just show which is that letter of 30th, which is asked for cancellation. Where is that document? Just find out.
It may be somebody else has some.
আমাকে না আপনি চাওয়াল আর মাইকে
Right. Keep that. Keep. No. আর দুদিন লাগবে provided I get to তাহলে
No, my lord.
Yes.
No, my lord.
No.
no. So this defense. No, next. This defense. Now, this, when was the written statement? Would I be correct that the written statement in the proceedings by Mr. Vishwakarma, your successor in interest of Circus Avenue branch, filed written statement after after 5 long years in July 2019, when all this defense of R41 and R42 were taken. or 41 or 42, or money coming in after banking hours was taken. You can see the written statement
written
if you want to.
statement, which कौन सा written statement दिया? हाँ?
Written statement. 6-9.
Yeah, written statement in one. CS 169. Written statement.
Statement of CS 169.
Right. 5 years বলেছি, 6 years হবে।
तो हुआ है written section 230 हाँ हाँ एंडिंग में टाइम मत दो टाइम मत ठीक है बात में
Initiate.
My lord, in this document, in page number 14, 15, 19, 20, reference of RTGS is there, and in page number 20, regarding R41, R42, those things are mentioned.
Those things are regarding
R41 and R42 is mentioned.
R40
1 and R42 are mentioned.
are mentioned.
And that was by a branch manager almost 5 years or 6 years after the zonal head came out with a case, filed a suit, not referring to R41 and R42, but only disputing the issuance of a letter dated 30th August 2012, signed by Alois Lakra, where the bank account 496, ending with 496, was linked with WBI FDC. You can see annexure কত ওটা ছিল blank, annexure blank of the plaint for which delivery up and cancellation has been sought. কত annexure কত? Huh? Annexure কত? C1, which is this letter, 30th. Just give me annexure. Annexure, এটা কত? Annexure C, page 24 of the plate. এটাই তো? না না আরে only that letter I'm talking about. Yeah, this one. Yes. This one. এটাই তো UCO Bank that. Yes. The plane, show the plane, please.
Where is the plane?
কোন প্লেনটা?
Which plane?
Filed by UCO Bank. Yeah.
Bank plate.
Sir. Page number 1 is also cancellation of this whole and the
Annexure C আছে কি?
Annexure C, page 24.
Annexure C हुआ क्या आपके पास से? उसमें annexure C है? उनको देखो.
It is annexure.
Kindly repeat the question.
Please repeat the question.
And what was by branch manager almost 5 years or 6 years after the zonal held filed a suit not referring to R41 and R42, but filed a dispute to the issuance of letter dated 30th August
30th August.
30th August 2012, signed by
Alois Lakra, ALOIS.
Where the bank account ending with 496 was linked with WBIDFC. You can see the annexure C is 24 of the plate and till the cancellation of the short.
My lord, this annexure C is the signature in place of Alois Lakra is not actually matching with the signature of Alois Lakra in our record. This has already been submitted.
Is not matching the signature of Mr. Alois Lakra in our record, right?
Yes. This has already been submitted and same answer I have already given.
So this was the only defense in 2013 by the zonal head who affirmed the suit by UCO Bank, and this new new aspect of R41 and R42 came in 5 to 6 years later in the written statement.
My lord,
Am I correct?
my lord, little descriptive I will say, if you will allow. If you will allow, answer will be little descriptive.
No, what is the answer? Then you can whatever then.
Why it is not mentioned, I do not have any idea. But R41 and R42 on which continuous discussion is going on in this court is significant because this is the type of remittance through which disputed transactions are remitted to remitting bank based upon the letter or intimation of WBIDFC with an account number in our Circus Avenue branch, which was itself incorrect. There was no account during that time of WBIDFC with UCO Bank. Being a organization, such type of mistake without checking or confirming whether they have an account or not, they are remitting high value of money twice. This appears the behavior of WBIDFC is not professional pertaining to these two remittances, which is causing subsequent difficulty for both the organization.
Finished.
One minute, sir.
Now, in the charge sheet against Alois Lacra, which is a disclosure in the proceedings, and in which you acted as management witness, sorry, charge sheet, in the disciplinary proceedings against Mr. Lara, in which you acted as management witness, did you raise this issue of R41 and R42, or even allow Alois Lacra to raise this issue of R41 and R42?
Being management witness, our scope is limited. It is the outcome of discussion of investigating officer and representative of the employee or employee himself.
I am suggesting to you that even Mr. Alois Lacra, sorry, neither UCO Bank in the charge sheet, nor Alois Lacra in its defense ever raised this aspect of R41 and R42 in the sorry, no, in the first one, it is 42.
His defense of R41.
R41. So R42 করেন। Sorry, what did I say?
I am suggesting to you neither the UCO Bank in the charge sheet nor Alois Lacra in his defense has ever raised this aspect of R41 and R42.
No, R42. In respect of the sum of rupees 59 crores and 59 crores 59 crores. As early as in 2016.
Yes.
My lord, I cannot comment on what is the charge sheet.
What is this?
Charge sheet and disciplinary action. But I can definitely say two things. Number one, this inward remittance is the sole cause of all disturbances. Second one is that the inquiry proceedings covered our internal guidelines pertaining to remittances, which is more stringent than the minimum checks suggested by RBI to be followed by banks operating in India.
And these stringent guidelines were adhered to you, and defense of Mr. Alois Lakra was rejected on the basis of your statement as management witness. That is my suggestion.
Whether it is correct or not.
On the basis,
Agree or disagree? Say first.
Whether
disagree.
I disagree.
Disagree. Before I show you the inquiry proceedings, I am suggesting to you that on the basis of your evidence that R42 guideline had to be followed, and money came in after banking hours, and thereafter, after 3 days, was credited by Alois Lakra and Gautam Ghosh. UCO Bank is stopped from disputing the remittance of the sum of rupees 59 crores, and the fault of these employees who were clearly fraudsters of UCO Bank. My suggestion, I mean, the implication will I come.
We agree or disagree, then we answer.
Disagree, my lord.
Yes.
First thing, this disciplinary action, I do not have any role in disciplinary action. Second, the sole cause of such issues was the inward remittance.
Yes, next.
Are you trying now to advocate the case of Mr. Alois Lakra, which failed in the in the disciplinary proceedings?
Not at all, my lord.
No. Please show the disciplinary proceedings. Please take, which is exhibit, which exhibit double L, M, which are pages, which are at pages. Ota dita hobe na. Sorry, double L. What pages double? Ek minute, huh? হ্যাঁ না এটা কন্টিনিউয়াস অনেক বড় তো না ওকে ওকে থ্যাংক ইউ এটা ভলিউম 1 ভলিউম 1 এ তো নেই রে কত 206 ওকে হ্যাঁ হ্যাঁ প্লিজ টেক অ্যানেকশন থ্যাংক ইউ exhibit LL being the copy of being the certified copy, no? Certified copy of the writ petition, which was filed by Alois Lacra. It is 196 দেখছি হ্যাঁ কত বলেছো 196 ভলিউম 1 196. So, please come straight away to 252, where the statement of allegations are mentioned. Please see para 6. ওটা পরে আসছে. I'm coming to something else. This para 6, page 253, where an entity called West Bengal State Marketing Board, Kolkata, and is mentioned. Is mentioned. How did West Bengal State Marketing Board come into the picture? Picture
My lord, it is a outward remittance.
Huh?
This is a outward remittance.
This is an outer remittance.
The pay order has been issued. Pay order has been issued. This is the outward remittance through pay order.
Yes.
when issued, why issued, by whom issued. On 10th September 2012.
My lord, I do not have idea who issued, when issued, how it is issued. But here it is written, transaction was verified by Mr. Lacra.
So, West Bengal Marketing Board was also having relationship with the same branch around the same period. Correct?
My lord, outward remittance, in case of outward remittance,
First you tell the whether it is correct or not, then you give the voluntary. What the question is
incorrect.
Incorrect. Then you whatever you want, you give the
No, in case of outward remittance, it is not necessary. The beneficiary will be a must be a customer of remitting bank.
Was
in case of outward remittance,
yes,
any relationship existing between UCO Bank, Circus Avenue branch and West Bengal Marketing Board? এটা কোথায় আছে?
No.
Please see again paragraph 3, the statement of allegations before I show you your evidence in the inquiry proceedings. In para 3, there is specific mention of a check favoring UCO Bank for rupees 10 crore odd on 4th August 2012
By
by West Bengal State Marketing Board, Kolkata, which is even prior to the transaction in question. Now, will you agree there was also another entity who was defrauded by this Circus Avenue branch? And that is why this has been mentioned as part of the statement of allegations.
I'll repeat the question.
Please see again paragraph 3, statement of allegations. Before I show you your evidence in the inquiry proceedings, in paragraph 3, there is specific mention of a check favoring UCO Bank for rupees 10 crore odd on 4th August 2012 by West Bengal State Marketing Board, Calcutta, which is even prior to the transaction in question. Now, will you agree there was also another entity who was defrauded by this Circus Avenue branch, and that is why this has been mentioned as part of the statement of allegation?
No, my lord, this is not like that. This is a check. This is a check issued by the entity in favor of SA Enterprises. If SA Enterprises ending with account number 496. I want to change this my answer. One check issued by the entity in favor of this account number, wherein beneficiary name was not mentioned. That has been written here.
So even prior to the remittance of 59 crore, there was another entity named West Bengal State Marketing Board, which also issued a check of Allahabad Bank favoring UCO Bank for rupees 10,40,97,762 as mentioned in para 3 of the statement of allegations dated 9th December 2013. Correct?
My lord, incorrect it is. Incorrect. My lord, some issue in understanding this, what is written in this point is happening. That is why problem is arising. Actually, in case of check, their check belongs to one bank's branch, Allahabad Bank, and the always it is in favor of some account holder, issued by account holder of, always in favor of some account holder. Here, what I understand from the content, in that check, account holder beneficiary name is not mentioned. That is why it was credited to one office account of branch. That is written.
Was it favoring UCO Bank?
Not favoring UCO Bank.
It is written it is favoring UCO Bank, and you want to say it was not favoring UCO Bank.
First thing, sir, this statement, I should not comment on this statement. I can only say always the instrument favors one account holder of a bank, not bank, not bank itself.
So a particular account was mentioned in the check, but name of UCO Bank was there.
What I understand from the
Correct?
this I understand from the content. Exact thing I cannot claim without seeing the instruments.
Now, I am going to show you a revision application filed by Agriculture Marketing Board, which is Exhibit FF in this proceeding.
Volume 3.
And at pages,
Volume
volume 3, page 140. Huh? 134. 130 একটু বার করে দে তো 1 134 ঠিক আছে ঠিক আছে ঠিক বলেছি yes 134 please turn to Good. Please come to 185, which is an annexure to this revision petition, right? Criminal revision petition filed by Agriculture Marketing Board. I am suggesting to you that as early as 31st July 2012, which is even prior to the issuance of the letter dated 30th August 2012, Mr. Alois Lakra, on behalf of UCO Bank, issued a similar letter to West Bengal Marketing Board, requesting check to be drawn in favor of UCO Bank account ending with 496.
My lord, signature not belongs to Alois Lakra, which is in our record.
Who has told you signature does not belong to Alois Lakra?
I am the successor of Alois Lakra, so in due course, I know the various time I have seen the signature of Alois Lakra from available records of branch. On that basis, I am saying this.
And in page 186, West Bengal State Marketing Board replied to this letter, referring to this letter of 31st July 2012, referring to this check of rupees 10,40,97762, which was being paid pursuant to the request made by Alois Lakra on behalf of UCO Bank. You can see page 186 of this volume 3.
What is the question?
And one
Next transaction.
And referring to this letter of 31st July 2012, referring to this check of rupees 10,47,977 which was paid pursuant to the request made by Mr. Brokerage on behalf of UCO Bank.
Three more questions and for this, just otherwise this part I. No, why should I compare?
My lord, on this I cannot comment anything before going through entire papers. This is, yes, this is written by some West Bengal State Marketing Board to UCO Bank, UCO Bank Circus Avenue branch. But what is the action taken place on the basis of this letter, I am unknown, so I should not comment.
Do you recall that in the midnight of 2012, before the zonal managed head,
2013, that is.
Sorry,
yes.
Sorry. In the early hours of early hours of 2013, bracket A, midnight, various officers, including you, various officers had accompanied you to visit the branch office of Circus Avenue branch?
My lord, this is not midnight, this is 2 a.m. Already I have submitted the statement, and various, I was not, I visited the branch much earlier of midnight. What I can remember, in the second half itself, I was in the branch. In the second, it was 2 a.m., not midnight, and I reached the branch in the second half of previous day, and nobody, every other officials were there in the branch. Nobody accompanied me to reach at the branch in midnight.
But zonal head, zonal officers were also there, either midnight, either late night of 2012 or early hours of 2013, when this inspection of papers was going on. Correct?
My lord, incorrect. Papers were not inspected.
Yes.
Transactions were tracked from CBS database, and other simultaneously some other interrogation, police reporting to police station, those activities which were need of that hour was taking place.
Do you mean to say report was made on 2000, early hours of 2013?
I only mean to say we are tracking the disputed transaction from Finacle server.
Were zonal other officers of the zonal office present?
Zonal manager himself, along with DGM from Field General Manager's office, frequently coming to the branch during that time, during the afternoon till 2 a.m. Stop. That much.
You mean to say they were coming from afternoon of 2012?
Matter happened in 2013, sir. My lord, why again and again 2012 is getting asked? I do not have any idea on 2012.
Did you visit the branch in 2012 late night or not?
No.
Did you did you visit?
Question is of 2012, kindly write.
Yes.
Visit the branch in 2012 late night.
Sorry.
No,
12th March 2012.
2013 it is.
Did you visit the branch? Correct my
Boss, please
on
correct your date and
12th March 2013. Taking of my
Already submitted, my lord. I was there from second half of 12th March 2013.
were zonal officers visiting from afternoon of 12th March 2012 or not? 13 or not?
Already submitted, my lord. They were visiting.
They were visiting. So zonal officers were visiting from afternoon of 12th March 2013, even before you visited.
Correct, my lord.
Correct. I am now suggesting to you.
Date is 12 March 2013.
13.
Sorry. Now, in the plaint which has been filed in UCO Bank by the zonal head, the discovery of these fraudulent papers, being the letter in particular, including the letter of 30th August 2012, were allegedly discovered during visit of zonal head along with officials of West Bengal WBI FDC only on 13th March 2013. That is my suggestion on the basis of what has been stated in the plaint.
My lord, this surface of a fraud and occurrence of fraud. In normal course, occurrence happened earlier and surface do take place in a later date. I think there is a confusion regarding this. If this concept, through this concept, confusion could be clarified.
Do you seriously contend that a fraudster will put a document of 30th August 2012
My
in
lord,
the system?
30th August 2012, I was not in that branch.
I am suggesting to you that the entire evidence or statement in the plaint that the document of 30th August 2012 did not contain the signature of Alois Lakra, or that the contention of UCO Bank that the document did not emanate from UCO Bank is completely false and incorrect.
My lord, two documents are presented today. Annexure C1S.
Presenter, what the question, whether you say yes or no, then you clarify, sir. Whatever you giving the clarify, I will sit till 12 midnight. The advocate is putting some question, you giving some question, and the court is saying all these things. What the question, you give the answer, then you want to give the voluntary, you give the voluntary. 100 times I told you. Not to be very intelligent.
Annexure C, as I have told, that doesn't bear signature of Alois Lakra. That signature was not matching. And page 36, Annexure D, page 185, Annexure D, it is also doesn't bear signature of Alois Lakra.
Does not bear the signature of Mr. Alois Lakra.
That's all? No, the other transaction I'll put, and the FDs I will put, and if they give, my lord, I will also put it from. Otherwise, more or less, my lord, I just in
কদিন
case
লাগবে একটু বলে দাও,
uh,
একটা বিষয় হবে।
whether they produce or not produce, I will.
The defendant witness, plaintiff,
Defendant witness.
defendant witness is present. Cross-examination resumed, but due to paucity of time, here cross-examination could not be completed. Accordingly, cross is deferred. Let the matter appear. Give the date.
My lord,
October. October का date. पूजा छुट्टी में आएगा.
my lord, two things. My
My
lord,
lord, I had
your
taken-
lordship has reserved judgment in the other matter, application. I do not know.
No,
will
no,
they-
no,
No, I have
Lordship has not reserved the
I
judgment.
kept
Lordship is
pending till the
keeping it pending.
till the completion of this
That's right.
cross-exam.
Lordship will
Till the
keep it
completion of the
My
cross-exam.
lord, my lord, then please make it part heard, my lord. That's what I think.
Till the completion of no, I will not make a part heard. Yeah. Let the matter appear on 2nd and 3rd December 2025 at.
My lord, regarding that, the
Second and-
application at least.
Yes, I have kept because he has taken the plea that it will be traced out
that is not.
and I will dispose of that application when his cross-examination will be over.
My
You
lord,
are taking so much time for completing the
My lord,
cross-examination. What the court will do?
May I make one prayer, my lord? I was, my lord, taking, my lord, some dates, my lord, because he is outstation, my lord, manager. My lord, instead of 2nd and 3rd, my lord, if, my lord, it is available, 10th and 11th of December, my lord, he is, I'm very grateful, my lord, 10th and 11th.
10th and 11th.
My lord,
My lord, I am humbly praying, my lord. At least some in the application, my lord, if some
Application is
observation.
already
pending, my
recorded. Kindly go to yesterday order. I
It was
recorded.
indicated.
I expressly stated it will be decided at the time of completion of the cross. If it till the completion of cross-examination, he will not bring the document. I will close it.
Lordship's kind indulgence, my lord, to mention, my lord, item numbers 1, 2, and 3 of my lord's regular list, my lord, it was mentioned in the morning.
Hmm.
My lord, we had agreed for a time on Friday. My lord, Mr. Dutt has some problem on Friday. We had a word with Mr. Banerjee. We are, when if
So
it's
now,
convenient for.
what remains after the division bench order? Nothing remains. Come on that day. I will dismiss your application. In open court, I am telling after the division bench order, nothing remains in your application.
My lord, your lordship will be pleased to take it up on Wednesday. My lord. Friday, Mr. Dutt is not there.
No, I have no time. If you were then I will let it go to the after vacation. You adjusted that time. If you are not able to appear, I will go take the after vacation. You adjusted that time because
I
of
know.
the urgency. But after going through the division bench order, I don't think that this court having any authority to pass interim order now. What you are praying for? Have you gone through the division
Yes,
bench
yes,
order? Sitting
have,
here, I have gone through the total order. There's nothing remains to decide this court in your interim application.
That's a remarkable feat.
During the cross-examination.
It's a remarkable feat.
Then maybe.
My lord,
You find at page 83. So one page order.
Page 83.
83, my lord.
Application or disposed of. What about the CP?
Yes, it says, my lord, perhaps the petition, my lord, the orders were passed in terms of the petition, but the
What about the
language is written application. I don't know what actually transpired there.
CP 444 हम लोग के पास है कहाँ गया CID गया तो आपका रिकॉर्ड होगा how the company office is functioning आप you not maintain any record which has been transferred to the NCLT. There is no diary, there is no register, diary dispatch, there is nothing. हाँ हाँ वही तो हाँ तो you send your advocate on record to the department.
They've gone
they will
there, my lord.
ascertain with regard.
They've gone there, my lord, and they've been handed over, my lord, a case status which I have, but this does not really help us, my lord.
What is the status? Disposed of. तो CA dispose. CP क्या हुआ? Where is CP? CA तो dispose of तो order है. क्या? नहीं ये तो हाँ वही तो इसलिए आप उनको send it. They will check whether the record has gone to NCLT or not. CP because they are CA disposed of.
Yes,
CP
because there was nothing really left in the CP also once that CA was disposed of.
Send the advocate on record to the department after now tomorrow whatever it may.
Grateful.
My lord, may I be mentioned when two company matters, there is a typographical error in the cause title and also in the name of the advocate. Let
Name
it
of
appears to be mentioned in the cause
Okay,
title.
to be mentioned the next week
Keep your-
for correction करके हाँ. Yes, call the list. Yes.
My lord, may I please? My lord, dealing with my lord, 2009 allotment.
Yes.
My lord, the first point, my lord, I made, my lord, was with regard to the notice. My lord, under certificate of posting, my lord, I have shown you
Not
the document and my lord, the case which was Sindri Iron. Then my lord, I have my lord also my lord said, my lord, that if my lord really my lord company was in need of funds, there is no explanation as to why my lord a rights issue was not had, my lord, where my lord everybody could my lord contribute. Particularly my lord as my lord for the earlier my lord issue and allotment of shares, my lord, your lordships, my lord, would have noticed, my lord, we had subscribed more than our entitlement because we were keen on, my lord, picking up shares. Then, my lord, third, my lord, argument which I had advanced before your lordship, my lord, was, my lord, that the company was not in need of funds. My lord, I have shown, my lord, the bank balances of the company and, my lord, the amount, my lord, which came in, my lord, by, my lord, this, my lord, share allotment, which was only 60 lakhs, my lord, which was 1/6 of the amount which was lying, my lord, in the bank account in cash, and it's not been utilized, my lord, in any manner, my lord, for, my lord, expansion, modernization or anything. And my lord, coupled with this, I pointed out, my lord, that in the documents, my lord, which have been disclosed, nothing has been shown, my lord, by the banks, my lord, asking us, my lord, that, my lord, if, my lord, there were to be further borrowings, there had to be, my lord, promoter contributions. In fact, none of that, my lord, has happened. My lord, lastly, my lord, I was on the valuation of shares. My lord, I had indicated to your lordships, my lord, that, my lord, three things I will indicate. My lord, that's where I was, my lord, on the last occasion. My lord, kindly take, my lord, the explanatory statement first. My lord, to, my lord, this meeting. Which is it in the note? My lord, kindly take, my lord, page 362, my lord, which is part of, my lord, the reply document disclosed by them in, my lord, volume 2. My lord, I hope your lordship's taking today, my lord, till 3.
Yes.
Because there is, my lord, a 3
Other-
o'clock fixed, so I, my lord, fixed to another matter, my lord.
Okay, no problem.
My lord, kindly take, my lord, 362, my lord. This is the explanatory statement.
Yes. Item number.
Item 2, my lord. Kindly see, the company, in order to meet the fund requirement, kindly see, for its expansion and other working capital requirements, proposes to issue an allot as and when necessary. Kindly note, as and when necessary. No, my lord, urgency. Equity shares on preferential basis to persons, body corporates and other investors, whether they be members of the company or not. Section 81 1A provides, etc., special resolution. Then, my lord, particulars as required under the aforesaid rules are as under. Equity shares of 10 each will be issued for cash at a premium of 5 per share. So, my lord, 5 rupee premium, my lord, on that page. And next, my lord, is very important. Relevant date taken for purpose of arriving at the price is the date of the last audited balance sheet of the company as at 31st March 2008. So, my lord, valuation, my lord, for the purpose of arriving at the price is that. And now, my lord, kindly have a look at 363. My lord, names of proposed allottees. My lord, is, my lord, the respondents group and, my lord, their friends, the beds.
Yes.
And, my lord, if your lordship sees, my lord, the
53.5.
yes, my lord. Kindly have a look. At the end of the day, my lord, 53.18 is held by promoters, etc.
Yes.
The post issue will be 79.
79.61.
So, my lord, it's, my lord, an absolute, my lord, majority, my lord, which was being created. Now, the valuation which has been done, my lord, was to be as of 31st March 2018, but contingent liabilities, my lord, have been taken into account, my lord, as of, my lord, 20th May 2009. Kindly have a look, my lord, at page 331. My lord, sorry, 371, not 331, my lord, 371.
Yes.
My lord, these are the chartered accountants who, my lord, did the valuation. We have verified the books of account along with all other documents, records, so and so for the year ended. Kindly note 31st March. This was, my lord, audited.
Correct.
Now, my lord, based on the annual report and audited accounts for the said year and the information given to us relating to contingent liabilities of the company as on 20th May 2009 and other information as is true and correct, to the best of our, we hereby certify intrinsic value. So, my lord, contingent liability, my lord, has, my lord, been, my lord, considered.
Yes.
Which, my lord, could not and ought not to have been done. Lordship will find that at page 372. This is of May 2009. My lord, which is considered. Kindly see, my lord, valuation of shares. My lord, Lordship has 372.
Yes.
NAV method based on audited accounts
Correct.
up to 2008, no problem. Then, my lord, we come to, my lord, the penultimate entry of less contingent liabilities, which is of a period subsequent to, my lord, 31st March 2008. My lord, at the bottom of 372, my lord, your lordship will find.
5.4, yes.
My lord, 4 lines from the bottom, less contingent liabilities, 7 crore 59 lakhs. So and so.
Yes.
And on that basis, my lord, the valuation, my lord, has been done. So, my lord, first, my lord, it's contrary, my lord, to the explanatory statement. My lord, it is not based, my lord, solely on 31st March 2008, but takes into events subsequent to that. My lord, second, this contingent liability was not part of any audited account as on that period. My lord, when, my lord, the valuation is done. It's subsequent to 31st March 2008. Contingent liability, my lord, as on that date, is not part of any audited account on the date of valuation.
Why you are telling this?
My lord, the certificate itself.
Okay.
Certificate talks of audited accounts for, and my lord, year ending is 31st March 2009.
And May.
This is, my lord, 10th May 2009. Now, my lord, second, my lord, I had pointed out on the last occasion, my lord, that the figures which have been given, my lord, with regard to investment and, my lord, term deposits, etc., do not tally, my lord, with, my lord, the audited accounts. If your lordship compares 555 with, my lord, page 555, volume 3, with page 372,
Yes.
my lord, first thing, my lord, page 372, your lordships will see, my lord,
Doubtful.
my lord, fifth entry, investment,
Investment.
net of doubtful, nil. Now, kindly see the audited account for 31st March 2008.
2,50,000.
2 lakh. My lord, they say they rely on audited balance sheet, and my lord, it's totally different. Next. Now, my lord, kindly have a look at, my lord, debtors, net of doubtful.
Yes.
My lord, in page 372, my lord, it's 2 crore 88 lakh 2,935.
Yes.
My lord, kindly have a look at the audited balance sheet. My lord, it is, my lord, over 3 crores. 3 crores 58 lakh.
58 lakhs 2,900. Yes.
So, my lord, all assets, my lord, are being reduced for the purpose of valuation. Then, my lord, loans and advances. Kindly see, my lord, page 372. My lord, it has been taken as 1 crore 65 lakhs. Actually, my lord, it's the same.
Loan and advance.
Slight difference, 1 crore 66 lakhs.
Yes.
Now, my lord, what is important is, now kindly take, my lord, the company had term deposits with banks. Kindly look at the valuation, my lord, 372. An asset has been deducted.
6,77,000.
It's less. My lord, it's supposed to be net asset value. The value of fixed deposits which I have kept should have been kept in, my lord, not deducted. It's been deducted.
Yes.
So, my lord, a deliberate attempt has been made. Deliberate attempt, my lord, has been made, my lord, to, my lord, depress, my lord, the value.
Yes.
Then, my lord, we also said, my lord, there has been no expansion, no modernization, no working capital, my lord, usage of these funds. Instead, my lord, we have, my lord, made out a case, my lord, of motor vehicles, etc., my lord. Your lordship recalls, my lord, BMW, etc., my lord, of which it has been, my lord, used. Now, my lord, net worth of the company, my lord, has been certified, my lord, as, my lord, between 5 crores and 20 crores by a rating agency. Your lordship's aware, CRISIL, SME rating, etc. My lord, they are registered with SEBI. My lord, they, my lord, rate, my lord, entities, my lord, for, my lord, their instruments. So that if I want to have a deposit, my lord, with them, if I see credit rating AAA, my lord, I might, who's a conservative investor, my lord, give that, my lord, as a deposit. My lord, kindly see, my lord, the valuation which has been done, my lord, page 446, my lord. on the basis of accounts, 13th March 2009.
Yes.
My lord, and my lord, addressed to the company itself, to Praveer Garg.
Yes.
My lord, he is the respondent number 2.
Yes.
Then, my lord, kindly see rating certificate and report of your company. We refer to your application for SMERA rating and are pleased to inform you that SMERA has assigned a SMERA B2 rating to your enterprise. Rating indicates high credit worthiness, namely 2 on a scale of 1 to 8 and belonging to B size category in terms of net worth, that is net worth of INR 5 and 20 crores. Please find the rating certificate, and the rating certificate, my lord, has been given.
Yes.
Now, what is important is, my lord, the valuation of the company, your lordships would have seen at page 372.
Yes.
My lord, is, my lord, 16 crores 86 lakhs, 16 lakhs, sorry,
16,86,000.
1,553.
Correct.
Nowhere near 5 crores.
Yes.
So, my lord, clear case, my lord, of, my lord, undervaluation, my lord, as far as, my lord, these, my lord. Now, my lord, most importantly, my lord, to an outsider, now, my lord, your lordships would have noticed, my lord, that, my lord, outsiders have also come in, my lord, because, my lord, at, my lord, the explanatory statement at page 362, who are, my lord, friends, my lord, of the respondents, at 362, my lord, your lordship will find, my lord, the beds.
Yes.
So, my lord, family majority control, my lord, is being part of it, my lord, is being ceded, my lord, to, my lord, outsiders. My lord, about, my lord, 12 odd %. My lord, beds, my lord, your lordship will see, my lord, post allotment, my lord, is 12.70. My lord, serial number 4 and 5, my lord, your lordship adds the last column, my lord, 6.35, 6.35.
Yes.
So, my lord, they outsiders get, my lord, more than 10 and I am below. I'm pushed, my lord, to, my lord, less than 9%. 9%. Now, my lord, kindly see what the view, my lord, now of the appellate tribunal is. My lord, I just want to cite this case, my lord. My lord, my lord, where outsiders, my lord, come in like this on the basis of a preferential allotment, my lord, itself is an act of oppression.
Yes.
The law there above the High Court. My lord, and the reason, my lord, why I am citing, my lord, an appellate tribunal judgment today is, my lord, through, my lord, legislation, my lord, they are, my lord, today the appellate forum in place of the High Court. Otherwise, I would not have. But, my lord, this is in consonance. This is in consonance, my lord, with, my lord, judgments, my lord, of, my lord, the High Courts, that, my lord, creation of a new majority. And here, my lord, it's not just creation of, my lord, an absolute majority. It's, my lord, a simple majority. It's creation of an absolute majority. New absolute majority and induction, my lord, of, my lord, outsiders having over 10%. And, my lord, reduction of the shareholding of insiders to below 10%, who are part of the extended family. And that your lordships, my lord, will find, my lord, I'll just indicate the para numbers. My lord, I'll only place 2 of them. My lord, paragraph 2, my lord, paragraph 2, 10, 11, 49, and, my lord, 57 to 60.
Yes.
My lord, kindly see paragraph, my lord, 58. My lord, which is, my lord, print page 17 of that order, my lord.
Yes, got it.
Admittedly, the respondent number 1 company consists of 3 families namely Shah, Nehlani and Poddar, with their respective shareholdings of 18, 31, 50. However, the respondents with their brutal majority, board of director transfer company shares to outsiders against original articles. This has caused a reduction in the appellant shareholding in one. This appears to be a deliberate act, sole motive to frustrate so and so. Then, my lord, therefore, in the circumstances, etc., is described as, my lord, oppressive, discriminatory, and deserves to be set aside. And my lord, one other, my lord, issue, my lord, apropos, my lord, the 2009, my lord, issue and allotment of shares. My lord, kindly see the guidelines provided, my lord, in the company's auditor's report order has also not been complied with in respect of the 2009 allotment. What have you entered? Okay. Now, my lord, why do I say so? My lord, the auditor, my lord, in the auditor's report, my lord, has not certified that the price and or valuation of shares issued was not prejudicial to the interests of the company. Now, my lord, your lordships will find, my lord, if your lordship takes, my lord, that CARO, my lord, we refer to it as CARO, Company's Auditor's Report 2003. My lord, kindly come to clause 4, my lord, which is, my lord, of that order.
Yes.
Matters to be included in the auditor's report. Lordship has that. The auditor's report on the account of a company to which this order applies shall include a statement on the following matters. Namely, now, my lord, kindly come to the last page. My lord, subclause 18.
Yes.
Whether the company has made any preferential allotment of shares to parties and companies covered in the register maintained in so and so, and if so, whether the price at which shares have been issued is prejudicial to the interest of the company. There is no such statement.
Yes.
And, my lord, kindly see, my lord, in this context, page, my lord, 329. 329. Next one. My lord, 329, my lord.
Yes.
It is admitted, my lord, by them, my lord, in, my lord, the auditors, the company has made preferential allotment of shares to parties or companies covered in the register maintained under 301. So, having done that, they were required to say, my lord, that, my lord, whether price had been, which shares have been issued is prejudicial to interests of the company. Auditor has not taken responsibility, my lord, apropos that. Yeah. Now, my lord, kindly come to the next point, my lord.
Yes.
My lord, if we go back, my lord, to the order. Yes. My lord, there's one judgment on valuation. Is it there or not there? Where? My lord, which I wanted to cite, my lord. My lord, on valuation, my lord, your lordship's aware, my lord, generally court does not go into valuation because, my lord, it is not, my lord, an expert science. But, my lord, the Supreme Court has held, my lord, that, my lord, where, my lord, a wrong principle is adopted, or, my lord, a glaring error, my lord, has been committed, courts will, my lord, not go by the valuation report. My lord, I had occasion to argue this and lose. So I remember, my lord, this, my lord, case. My lord, kindly come to para 32. Oh, 2007, 5 Supreme Court cases, 133. Mr. Ratnako Banerjee was my junior in this. My lord, kindly take para 32. My lord.
Yes.
My lord, print page 20.
Yes.
My lord, 6 lines from the start of that paragraph. Sentence starting, if the valuer. If the valuer. Your lordships have that?
Para 32.
32, my lord. these decisions,
Yes,
it
yes.
starts clearly laid down.
Yes.
My lord, 5th line, if the valuer adopts
Yes.
the method of valuation prescribed, or in the absence of any prescribed method, adopts any recognized method of valuation, his valuation cannot be assailed. Now, kindly note this. Unless it is shown that the valuation was made on a fundamentally erroneous basis, or that a patent mistake had been committed, or the valuer adopted a demonstrably wrong approach, or a fundamental error going to the root of the matter. Where a method of valuation is prescribed, the valuation must be made by adopting scrupulously the method, taking into account all relevant. Now, my lord, here, my lord, my respectful submission, my lord, to your lordship is, my lord, not only, my lord, was it made on an erroneous basis, patent mistake. My lord, why I say so? My lord, valuation says 31st March 2008. They look at, my lord, a 10th May 2009 contingent liability. Second, my lord, they say, my lord, it's on the basis of audited accounts.
Yes.
But, my lord, figures taken, my lord, for the purpose of valuation do not tally with, my lord, the audited accounts,
Yes.
which have been disclosed. And, my lord, this is, my lord, a clearly, my lord, demonstrably wrong approach. Then your lordships, my lord, kindly come to para 37.
Yes.
My lord, it says, my lord, basically the same thing, 37, and then, my lord, para 84. My lord, paragraph 84. My lord, print page. I've given him credit also for being this.
Now you distinguish this.
My lord, I can tell your lordship, my lord, what happened in the matter. My lord, Mr. Banerjee and I, we were stuck in another matter. My lord, in Delhi. My lord, there were two, my lord, matters. My lord, Mr. Dushyant Dave was in the other matter on behalf of the appellant. And my lord, he had, my lord, argued. And we came in just after, my lord, he had, my lord, concluded. And my lord, when we started, my lord, the judges, my lord, observed, my lord, as to whether, my lord, we were giving the basis of the arguments of Mr. Dave. In other words, my lord, Mr. Dave had missed out the basis of his arguments. And he wasn't happy with that.
He got very upset. He came and told me, no, tell the judges I gave the base also.
I remember that. You know, that was. My lord, para 84, your lordship will again see, my lord, page, my lord, print page 34, my lord, after 6 lines, unless it is shown.
Yes.
That some well accepted principle has been departed from without any reason, or that approach adopted is patently erroneous, or that relevant factors have not been, valuation was made on a fundament adopted, going in, this court would not interfere. And that is exactly, my lord, what we have, my lord, tried to demonstrate. Now, my lord, your lordship might have noticed that, my lord, in the impugned order, my lord, all these points, my lord, which, my lord, we had, my lord, relied on, and, my lord, have not been dealt with, though in our arguments, my lord, it has been recorded. That I showed your lordship, my lord, because this starts, my lord, goes up to, my lord, paragraph 10. My lord, it starts from para 9, and, my lord, goes up to, my lord, paragraph 10. Other than the notice issue and, my lord, the allotment of shares, my lord, under 81(1)(a) vis-a-vis, my lord, a rights issue, my lord, other matters, my lord, have not been, my lord, dealt with at all. Now, my lord, I come to, my lord, the last allotment, my lord, of 2011. Now, my lord, paragraph, if your lordship kindly goes back to the memorandum of appeal, my lord.
Yes.
My lord, that's para 11, my lord, to para 15. My lord, kindly see, my lord, paragraph of the, my lord, of the memorandum of appeal. My lord, it, my lord, starts, my lord, internal page, my lord, is, my lord, page 23 of the order. High Court order. The petitioners have also challenged the allotment of 2 lakh equity shares made on 23rd March 2011. The facts of the case of the petitioners in this regard have already been mentioned in so and so. In this regard, the respondents have contended that allotment was made after complying with the provisions of the Act. The notices for convening of EGM were duly received by petitioners, and the explanatory statement was also sent along with notices. Special resolution under 81(1)(a) was adopted on 23rd March, and minutes clearly show that special resolutions were passed unanimously. Petitioners 1 and 2 did not attend such EGM in spite of receipt and did not place any objection to passing off. The petitioners have contended that the explanatory statement attached to the notice regarding joint venture business in Sri Lanka was not adequate and hence not in compliance with provisions of 173 of the Companies Act 1956. Reliance in this regard were placed, several cases, my lord, are referred. Learned counsel for the respondents has sought to distinguish the above cases cited by the petitioners and submitted that sufficient information was given about Sri Lankan partner, and the petitioners, after receipt of the notices, never sought any clarification which tantamount to indifference towards the affairs of the company. The details of business partner are commercial secrets that need to be kept in perspective, since the respondents were only trying to find the suitable partner. The respondents have already filed the details of such partners along with reply, and therefore, according to the respondents, no further cause of action lies in the matter. So, my lord, our case was, my lord, 173 notice. My lord, your lordship takes, my lord, the Act once. My lord, required certain disclosures to be made. My lord, the provisions, my lord, are mandatory. My lord, which, give a copy.
Old Act or New Act?
Old Act, my lord, old Act. I'm just giving a copy. One 173.
Old Act नहीं है, यहाँ नहीं है, मंगा लेना. Yes.
My lord, kindly see, my lord, explain it to me. For the purposes of this section, my lord, kindly come to B. This wasn't an annual general meeting. B. In the case of any other meeting, all business shall be deemed special. Then, my lord, 2. Where any items of business to be transacted at the meeting are deemed to be special as aforesaid, there shall be annexed to the notice of the meeting a statement setting out all material facts concerning each such item of business, including in particular nature of the concern or interest, if any, therein of every director, the managing agent, if any, secretary, treasurer, and the manager, so and so. Then, my lord, provided that where any item of special business as aforesaid to be transacted at a meeting of the company relates to or affects any other company, the extent of shareholding interest in that other company of every director, so and so, if any, and the manager of any of the shall also be set out in the statement if the extent of such shareholding is not less than 20% of the other. Where any item of business consists of the according of approval to any document by the meeting, time and place where document can be inspected shall be specified. Like, my lord, if the articles are being amended, my lord, reasons, material facts have to be given, and my lord, inspection, my lord, should be provided, my lord, of that document. Now, our case was, you are seeking a resolution, my lord, to enter into a joint venture with, my lord, a partner, my lord, in Sri Lanka. Now, my lord, the identity of the partner, my lord, needed to be disclosed, which has not been disclosed. My lord, what they say is, we didn't disclose it in the notice because there's a secret, but I've disclosed it in the reply, and therefore you have no cause left. My lord, if I had a cause, my lord, that he should have disclosed it in the notice, subsequent disclosure in affidavit cannot cure, my lord, the notice, because meeting has already been held. Then, my lord, kindly see, according no further cause of action, since the business by way of joint venture with Sri Lanka partner has not fructified finally, challenges made by petitioner in this regard have lost its meaning, and therefore no further interference is called for on this issue. Now, my lord, what do they say? My lord, everything, the basis of, my lord, all Kindly see, my lord. Then paragraph 14, petitioners have challenged the valuation of shares arrived at by the company. According to the respondent, such valuation was undertaken by its statutory auditors based on accepted principles of valuation. It has been submitted that petitioners have given 4 different kinds of valuation, where the valuation which shows that even the concerned valuers have valued the shares differently, and therefore it has been contended that such valuation, the respondents have relied on Hindustan Lever Employees Union to submit that because there can be another method of valuation which is more favorable, cannot be a ground for non-acceptance. It is the case of petitioners that they have complied with unlisted public companies' preferential rules and have not committed any wrong, because in my considered opinion, since the special resolutions have been passed by requisite number of shareholders and there has been strict compliance of allotment rules certified by statutory auditors towards, and in the absence of any ulterior motive which can be imputed on the respondent group of shareholders, no interference is called for to the preferential allotment. Now, my lord, this is, now kindly have a look, my lord, at, my lord, the, my lord, first, my lord, kindly have a look at the explanatory statement.
Yes.
My lord, 2, my lord, this, my lord, which is volume 1, page 240. My lord, this is, my lord, the notice of, my lord, the 2011, my lord.
Yes.
Notice is hereby given that meeting of members of Waxpol so and so will be held. Now kindly have a look to consider and if thought fit to pass with or without modification the following resolutions. Now, my lord, first is alteration of the objects clause. Kindly see. Resolve that pursuant to section 17 and other applicable provisions of any of the Companies Act, the main objects clause being clause 3A of the memorandum be altered by insertion of the following subclause 4 in the main objects. Now kindly see. To enter into partnerships or joint ventures or any other arrangements of union of interest, reciprocal concession or cooperation with any person or companies carrying on or engaged in or about to carry on or engage in or being authorized to carry on or engage in any and or all business or transaction which this company is authorized to carry on or engage in, or transactions capable of conducted so as directly or indirectly to benefit in this company either in this country or in a foreign country, and to subscribe into capital of the said entities and otherwise invest the funds of the company in accordance with laws. And, my lord, to take or otherwise acquire and hold shares in any other company or company having objects altogether or in part similar to those of the company, or carrying on business capable of being conducted to directly or indirectly benefit this company either in this country or foreign country. So, my lord, basically what they're saying, you kindly allow the objects of the company to be amended, allowing it to do this kind of business by entering into partnerships, my lord, in this country or foreign country, my lord, where, my lord, the company is carrying on similar business, or, my lord, is, my lord, in a position, my lord, to, my lord, carry on business to the benefit of this company. And, my lord, to do this by acquiring and holding shares, my lord. And then, my lord, kindly have a look at 2. To consider and if thought fit to pass with or without modification the following resolutions. Now, my lord, this is again after all approval, so and so, my lord, 6th line. company B and is hereby authorized to offer, issue and allot up to 2 lakh shares of so and so at a premium of 10 per share to such persons and other investors in its absolute discretion may decide. Now, Millard, the next resolution is resolve that consent of the company is given for formation and incorporation of a joint venture in Sri Lanka with suitable overseas partner, etc. And then, Millard, kindly take, Millard, the last resolution, penultimate resolution, resolve further that Board of Directors BNI hereby authorized on behalf to give and or delegate authority to such person to enter into and execute memorandum of understanding with Sri Lanka partner or partners for formation on incorporation of joint venture in Sri Lanka and to appoint such. Now kindly have a look at the explanatory statement at page 242. Millard, so Millard, item 1, Millard, item Millard 3 and item Millard and item 4, Millard, are Millard, all Millard covered under Millard item 1. The company referred to as Waxpole proposes to enter into a joint venture for formation and incorporation of a new company to undertake manufacture of company's range of products in Sri Lanka in accordance with law of both the countries, so and so. Waxpole proposes to invest in the equity of the proposed company to the extent of 51 and balance 49 will be invested by Sri Lankan partner. Your directors feel that proposed joint venture can be economically, conveniently and efficiently combined with the existing business and will be in larger interest and benefit of the company and shareholders. Proposed venture will conveniently and advantageously combine with business of the company under existing circumstances when central government is opening the economy and going for liberal industrial policy. Present trend in international has thrown several opportunities, etc. So, my lord, this is, my lord, indicating, my lord, that now, my lord, kindly come to item 2. My lord, at page 242, my lord, third line.
Yes.
The company, in order to meet the fund requirement for the aforesaid expansion, proposes to issue an allot as and when. So, my lord, this is for expansion.
Yes.
Kindly note valuation date, my lord. Particulars as required are given. Last clause B, relevant date is 31st March 2010. And, my lord, here again, kindly see, my lord, this preferential allotment which is happening. Now, my lord, it goes up to 84.10%. My lord, 243. My lord, under E, my lord, promoters direct intend to subscribe to the offer fully. And my lord, the chart, my lord, is there.
76. Yes.
My lord, below that, from 79.61 held by directors, their relatives and corporate so and so under their control, post issue holding will be 84.1.
Yes.
And my lord, again, my lord, beds, my lord, the outsiders, my lord, get, my lord, more shares. Now, my lord, item 3, kindly see, Sri Lanka, my lord, and my lord, fifth line, company has identified a couple of prospective parties who are interested in and are working out modalities for entering into a new body corporate is proposed to be incorporated, 49%, etc., etc. My lord, this was. And then, my lord, 244, my lord, again, enter into joint venture, incorporation, etc. Now, my lord, this was challenged.
Yes.
My lord, and an order, my lord, was passed, my lord, by, my lord, the High Court, my lord, under section 10F, my lord, which is in volume 2, my lord, page, my lord, 257.
Yes.
My lord, 6th of April 2011, my lord, is, my lord, the order. My lord, we asked for, my lord, interim protection, my lord, as far as this is concerned. My lord, third line, this is an appeal against the order of Company Law Board made on 24th March. Company Law Board refused any interim order. A substantial ground taken in the appeal is that although there is discussion of rival cases of parties, the impugned order is lacking in reasons. Whatever reasons have been given in the order are most unsupportable. The two fundamental grounds have been taken by the appellants. The company proposes to do some business in Sri Lanka as a joint venture business with a collaborator or partner. The decision to take such business was taken as a special resolution. It is stated that company was required to disclose all material facts with regard to such business, but that information was not there in the notice dated. Such information was lacking in the explanatory statement. The next point taken is with regard to resolution for allotment of equity shares. It is submitted before me that the allotment is in violation of section so-and-so, read with so-and-so. It is submitted that in the said resolution, no price was mentioned as is required under the rule. Further, no time limit for such allotment is mentioned. According to the appellants, a share of rupees 60 has been sold at rupees 20. And appellants are highly aggrieved by the refusal. Company Law Board record as to issue an allotment, since the members have already made allotment, it cannot be undone. Here in a petition under so-and-so have to prove not only violation but also prejudice. It is submitted that such order was passed on assumption. Moreover, members cannot allot shares. On the other hand, Mr. Banerjee, learned counsel for the respondent, submitted that the petitioners have not been in the forefront for a long time. They have accepted an earlier reduction of capital. They have been enjoying dividend paid to them. The cause of this action is to harass the persons in control. I am of the opinion that under the Act, the company was required to make a detailed disclosure, kindly note, about investment in Sri Lanka. Its omission to name the collaborator or the amount of investment or projected investment in the said notice and explanatory statement amounts to non-disclosure under the Act. In my judgment, however, shareholders have approved this resolution by requisite majority. But I make it clear that such investment in Sri Lanka will strictly abide by the orders to be passed in the 397, 398. Further, I am of the opinion that there is some substance in the other argument of the appellants. There was some obligation of the company under 81(1)(a) of the Act, read with the rules. I do not find any indication of the price of the shares or the date of completion of the allotment. The question of undervaluation of the shares has to be gone into in section 397, 398. Therefore, this appeal is disposed of by directing the respondent beneficiaries of equity shares allotted or preferential basis not to claim any right on the basis of such preferential allotment till disposal of so-and-so. I request the company law board to say all points are kept open. Yes. So, my lord, non-disclosure, my lord, was, my lord, clearly accepted, and non-compliance with rules, my lord, was quite prima facie, my lord, accepted here. Now, my lord, kindly see my lord, first point again, my lord, again there is no explanation as to why a preferential allotment had to be resorted to and not, my lord, a rights issue. Then, my lord, Kalinga, my lord, which I had relied on, my lord, for 2009, that's AIR 65 Supreme Court, yes. My lord, again, my lord, is, my lord, applicable here. Then, my lord, item 2, my lord, which is the allotment, says, my lord, that it will be made, kindly mark the words, as and when necessary, and to meet short-term and long-term financial requirements. Therefore, my lord, there was really no urgency, my lord, to go ahead, my lord, with this issue and allotment of shares. Urgently. Yes, because, my lord, they are not even sure whether they'll need the money or not. Then, my lord, the lack of any, my lord, urgent and immediate need of funds, my lord, is brought out, my lord, by, my lord, several factors. First, my lord, page 331, my lord, volume 2. My lord, this is part of the reply where they disclose this.
Yes.
Lordship will find, my lord, that profit before tax, after tax for the year ended 31st March 2010 was, my lord, 1.7 crores
After tax,
after tax.
before tax,
My lord, kindly see, my lord,
after tax,
10 lines from the bottom, profit after tax.
8,400,
No,
84.
no, above that, my lord. Profit
Acha.
after tax, 1 crore 70 lakhs 15,907.
Yes, 1 crore 71. Yes.
Then, my lord, the proposed dividend, my lord, for that year, my lord, kindly see, my lord, just 3 entries below that.
Yes.
My lord, 21 lakhs 25,900. So they have enough money. There's no urgency. And then, my lord, there are huge cash reserves of 5.23 crores, my lord, which is at page 335.
Yes.
My lord, kindly take, my lord, Schedule H. Cash. The heading is cash and bank balances.
Page
335, my lord. Same volume.
Yes. Schedule F.
My lord, this is, my lord, 5.23 crores.
Schedule F.
Schedule H, my lord.
H.
Cash and bank balances, my lord, is the heading.
Yes.
Last, my lord, the total, my lord, of this is 5.23 crores.
Yes.
And, my lord, interestingly, the money would come, which would come in, my lord, by virtue of this allotment, if fully subscribed, is 40 lakhs. My lord, kindly see page 391, when, my lord, the resolution was passed allotting the shares. 391, my lord, volume 2. My lord, 2 lakh equity shares. At a premium of 10. So, my lord, multiply by 20. My lord, 2 lakh into 20, my lord, is 40 lakhs.
40 lakhs.
Now, my lord, even otherwise, my lord, the shares, my lord, have, my lord, been undervalued. The lordship has seen 10 rupees face value, 10 rupees premium. But, my lord, the earnings per share, your lordships will find at page 331, my lord. At the bottom, my lord, is more than the value. Kindly see, my lord, 29.58. Even on their own balance sheet.
Yes. Earning per share.
Right, my lord, earnings per share. Last figure, my lord, 29.58. My lord, shares are being given, my lord, for 20 rupees. My lord, this is 29.58. It's going to earn, my lord, more than the value of shares. So, my lord, property, my lord, is, my lord, being sold at 1,000, but rental, my lord, receipt, my lord, is, my lord, 20,000.
Yes.
My lord, the sole objective, my lord, was, my lord, to, my lord, keep reducing, my lord, marginalize the petitioners, my lord, completely, my lord, from, my lord, the company. Now, my lord, what is even more important is, my lord, the extraordinary general meeting was held on 23rd March 2011.
Yes.
My lord, the time was, my lord, 11 a.m.
Correct.
Lordship will see that, my lord, at page 387, volume 2.
387. Yes.
My lord, it was only after this resolution could, my lord, any steps be taken, my lord, to, my lord, get people, my lord, to whom the shares are to be issued, to, my lord, apply and be allotted.
Yes.
Now, kindly have a look at 391. The allotment, my lord, which I showed your lordship, my lord, to show, my lord, the amount of money come in. And this is very important. Time is the same, date is the same. Resolution being passed, my lord, at my lord 11 a.m., 11:30, my lord, within half an hour, my lord, applications are supposed to be made. Kindly see, my lord, 391.
Certificate. This certified.
Certified true copy of resolution passed at so and so, same date, 23rd March, half an hour later. Now, my lord, kindly see what is happening. Resolve that statement showing names, addresses, number of shares applied for against so and so at a premium of so and so received, submitted to this meeting, and for the purpose of identification initial be and is hereby approved, and each applicant of shares be allotted so and so. Resolution meeting is held 11. EGM authorizing this, and applications have come, listed, everything done. Unbelievable, my lord, what is happening.
Yes.
And my lord, the important thing is, my lord, there was a preferential offer. That preferential offer,
Yes.
my lord, can only happen after the resolution is passed. At my lord, the meeting is at 11. So sometime, my lord, 11:03, 11:05, 11:10. My lord, there was a preferential offer, 391. Kindly see, board meeting is resolved. That statement showing names, addresses, number of shares applied for against preferential offer. So, my lord, company would have made a preferential offer, and then applications would have come.
That has been, yes.
My lord, and my lord, the important thing is, my lord, no particulars, my lord, that offer, the proposal, my lord, nothing is on record.
Yes.
So, my lord, it's predetermined mind, my lord, as to what is, my lord, happening. And, my lord, in the reply, my lord, which has been filed, this aspect of the matter, my lord, was not dealt with at all. Now, my lord, kindly have a look at the valuation certificate. And this is again, my lord, important. My lord, page 385. This is the last point I'll address today, my lord. Yes. My lord, page 385.
Yes.
My lord, kindly see, my lord. This is again the same, my lord. Chartered accountant.
Yes.
My lord, kindly see, we have verified the books of accounts so and so for the year ended 31st March 2010. Based on the annual report and audited accounts of the company so and so to given to us relating to contingent liabilities as on 31st March and other information true and correct, we hereby certify that intrinsic value is 6.91 per share. Now, my lord, kindly have a look, my lord. The calculation is supposed to be based solely on, my lord, the audited accounts of 2009, 2010. It takes into account, my lord, contingent liabilities, my lord, for this period. But, my lord, kindly have a look at the accounts of the company. Page 341. My lord, right at the top, clause 4.
Yes, contingent liability.
Not provided for. Now, my lord, if there is no provision, my lord, made for contingent liability in, my lord, the financial statements of the company, my lord, which have been audited, my lord, by, my lord, the chartered accountant, the auditors, and, my lord, have been approved by all the shareholders, my lord, there is no basis, my lord, again, to, my lord, reduce the value. My lord, kindly come to page 555. No, this is not it. 500. What have you done? My lord, page 386. This is the valuation. My lord, kindly see. My lord,
386.
Yes, my lord,
Yes, yes.
386.
Yes.
My lord, last but one entry. My lord, contingent, it's been, my lord, deducted from the valuation. 9 crore, 68 lakhs, 39,530. Lordship has that?
Yes.
My lord, the balance sheet says, my lord, it's not provided for. Yet for the valuation,
So this balance sheet of 31st of March,
yes,
as on 31st of March. And
no contingent liabilities. And this is,
liability, and
my lord,
this is
kindly see, my lord, valuation of shares, my lord, page 390, 386, left-hand top,
96.
based on audited accounts of 2009-10. Lordship has that?
Yes, yes. Same. Annual report, audited account.
My lord, this is contrary to the balance sheet. My lord, 341, my lord, right-hand side, your lordship will get the date,
Yes.
31st March 2010.
Got that.
Contingent liability not provided for.
Yes.
And my lord, yet, my lord, if it was 9 crores odd, my lord, how could, my lord, there be a dividend of, my lord, 21 lakhs then? If there is a deduction for the purpose of valuation.
Yes.
My lord, may I stop here today, my lord?
Okay. Counsel for the appellant had argued the matter at length, but due to paucity of time, hearing could not be completed.
Lord,
The cases are
last week, my lord, kindly don't, my lord, kindly keep it.
come after vacation.
Yes. Lord, if it commenced to your lordship, my lord, 5th November, my lord, which is a
November is
Wednesday.
holiday.
Oh.
And 12th November.
Very important holiday.
My lord, 12th,
Guru Nanak's birth.
huh?
Guru Nanak birthday.
And what was fixed there? Killing me.
The 19th.
19, my lord.
19th में कोई फिक्स है क्या हमारा? खाली है? At 2 p.m.
Nacho, 19th.
19th November 2 p.m.
My lord, is it your lordship's desire to mark it as part heard, my lord? My lord,
It is.
will, my lord. Otherwise, we'll suffer, my lord. The clients will suffer, my lord. Whichever way, my lord, kindly. We'll wait. But, my lord, let it be before your lordship.
As part.
Obliged, sir.
No, no. Right.
My lord, I was checking on Punjab and Haryana High Court holidays.
That's why it's a very important holiday now for us.
What does happen?
Obliged.
Anything further?
Obliged, sir.
His status is
Which one?
his status is showing as pending. Item number 6.
Which one? Item number 6.
6. Number is okay.
Huh.
Then dismissed. I have given the number. His status is only showing pending.
BIFR. The BIFR.
Number is there.
Okay. You are appearing? Anybody is appearing? No. Item number 6 record.
Item number 7, I am at.
In the website, the status of the BIFR /249 and 59/1992 is shown as pending, but by an order dated 8th May 2023, this court has dismissed BIFR/259/1992 for default. Accordingly, in the website, accordingly, the IT department, the registrar IT, is directed to correct the case status of IPBFR/259/1992 as disposed of instead of pending with immediately. Okay. Yes. Seven.
But I am for the official liquidator. Malad, by an order dated 30th January 2023, Malad, this matter has been transferred to NCLT.
NCLT?
Yes, Malad, kindly see the second
Same,
page.
na?
Second page, Malad.
In view of the aforesaid proceeding, BIFR, including all applicants, stand transferred to the NCLT. Kolkata Department shall treat the matter. So, you have not sent the document to the NCLT after this order. Have you checked? What number? IP 88, 87. BFIR 88 of 1997, 88, acha 97.
97. That's
So there is no BFIR 88, 97 is pending. And this it is fine from the record that there is no case BIFR/88 of 1997 within bracket Mrs. Small Tools MFG .co of India Limited versus official liquidator is pending before this court. It is found that the BIFR number is wrongly recorded as BIFR 88 of 1997 instead of BIFR 88 of 1987. It is found from the order dated 30th January 2023, BIFR 88 of 1987 has been transferred along with all applications to the National Company Law Tribunal, Kolkata. Accordingly, the registrar IT is directed to delete the case status of BIFR 88 of 1997 from the website, as there is no case pending being BIFR 88 of 1997. Next.
So far in respect 8 is concerned, Malad, the official liquidator has got record in respect of the CP number, but here it is mentioned BIFR number. So I am seeking, Malad, 1 week's time to 2 weeks time, Malad, official liquidator is seeking 2 weeks time.
mentioned as
After vacation.
1988.
1988
Disposed of. It is disposed of.
Yes, yes.
Earlier it's in 1998 it is disclosed.
I think it should be
1988. 98. Huh?
88, and the name is also wrong in that record.
So this is different one.
This is
AVJ Wires Limited. And there is the Central Bank of India.
wrong. It is wrong.
It is wrong.
I think now 98.
No.
There is no such BIFR case. 88. There is no such
No,
BIFR case.
this is already disposed of.
This program and the cost that is also
Wrong. No, it is there. 13 of 1998 HA Wire Limited. It is there.
yes, but in the recording order recording, the name is also good.
This one.
This is the recording Central Bank.
So, no, this is different one. No, this is 1980. Then there is no 1988 of Central Bank of India versus well.
No such BIFR case. No such BIFR case.
88 there is no such BFR case.
No such BIFR case. I have given in my note. I have given.
But why then court is recorded? It should be 98.
Yes, yes. It should be 90.
You're sure?
Because there is no such. I'm sure that there is no such BIFR case.
Interim case
It
available
might be.
in the no entry of the ledger maintained by the department as BFR 1998. However, entry of 80 is available and in the ledger the connected cost. So it is 88, not 98.
Yes, yes.
And the name is ABJ,
Yes,
not the central bank. Yes. It is disposed of.
Dispose of.
Actual number is not correct.
Right.
Number is 88,
80.
not 98.
No.
And name is not the Central Bank of India, ABJ.
ABJ.
But here the order passed in Central Bank of India. This cost order is wrong and this number is correct. By an order dated 24th February 2023, this court disposed of BIFR 13 of 88. 13 of 88. But in the order dated 24th of February 2023, in the end, the cost title of BIFR 13 of 1988 is regarded as Central Bank of India versus Official Liquidator. But in the case number of BIFR 13 of 88, the name of the party shall be Messrs. AVJ Wires Limited versus Official Liquidator. Versus Official Liquidator. In view of the above, in the order dated 24th of February 2023, the name of the party shall be read, name of the party in BIFR 13 of 1988 shall be read as AVJ Wires Limited versus Official Liquidator instead of Central Bank of India versus Official Liquidator. As the BIFR 13 of 1988 within bracket AVJ Wires Limited versus Official Liquidator has been disposed of by the order dated 24th of February 2023. Accordingly, the registrar IT is directed to delete the details of the BIFR 13 of 1998 with the cost title of AVJ Wires Limited versus Official Liquidator from the cost title from the website. Yes, next.
Or the same situation, no records with the official liquidator.
Nobody is there. What is the case status? I see you got anything?
Yes. Name is no.
Bharat Engineer.
65 of 88 and in our database it is 65 of 98. It should be 65 of 88.
Okay.
And name of the company is Kumar Dubey.
Kumar Dubey Fire Control, not by the Bharat Engineering. Here Bharat Engineer. McNally Bharat Engineering.
No, there is no such case.
There is no such case. And what is the status? 1988 is pending. Claim is pending. Therefore, the company agreement cannot be dissolved. Matter is sanitized. So it has to be brought on record. Okay, recorded. As per report submitted by the Assistant Registrar in Charge Company Matters Department, there is no case pending being BFR 65 of 1988 within bracket McNally 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 Bharat 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 Engineering Company Limited versus Official Liquidator. As per the report, BIFR 65 of 88 is pending with the name of the parties as Kumar Dhubi, KUMAR DHUBI, Dhubi Fire Clay W Limited लिख लेना versus so and so. It is found that by an order dated 6th July 2021, BIFR 65 of 88 be adjourned sine die. Accordingly, the department is directed to place the record of BIFR 65 of 88 before this court on the next date fix, that is on 24th of September 2025. The registrar ordinal side is directed to delete the case title case status of BIFR number 65 of 1988 with the cause title McNally Bharat Engineering Company Limited versus Official Liquidator from the website. Next.
Item number 10.
No records with the official.
Okay, the number is 4.
Hmm.
Number should be 244 1998. Disposal.
Party name is correct. As per the report submitted by the Assistant Registrar within bracket in charge Company Matters Department dated 17th September 2025, the BIFR number no case being BFIR 224 of 1998 is pending. He submits that as per the report, there is a case being BIFR number 244 of 1998 with the name of the parties Messrs. Sarala Gem Limited versus Board of Industrial and Financial Recons. By an order dated 3rd February 2023, BIFR 244 of 1998 is disposed of. In view of the above, the registrar IT is directed to delete the case number and case title being BIFR 224 of 1998 within bracket Sarla Gem Limited versus Board of Industries and Finance Recons from the website.
Item number 11.
Two 73.
7088. And the party name is also in the hospital's department is there.
Kusum Engineering, but here it is United Bank of
And the
India.
hospital also is there.
Hospital is United Bank of India, not Kusum
After
Engineering.
when in the matter of
Acha, Kusum Engineering. Okay. And disposed of? Transferred. The Assistant Registrar in charge Company Matters Department submitted the report dated 17 September 2025, wherein it reveals that no case being BIFR 273 of 1998 is pending. It is on that the BIFR 273 of 1988 having cause title Kusum Engineering Company Limited and UBI versus Official Liquidator was disposed of by this court by an order dated 24th of February 2023. In view of the above, the Registrar IT is directed to delete the case number BIFR 273 of 1988 with the cause title United Bank of India versus Official Liquidator within bracket in the matter of Kusum Engineering from the website.
This is also transferred to the NCL team. Two of the order.
513 1992 and disposed of. Party name is same. Assistant Registrar in charge Company Matters Department submitted report wherein it reveals that no case being BIFR 538 of 99 is pending. As per the report, there was a case being BIFR 538 of 1992 having cause title Mrs. Bengal Humanity Limited versus Union of India versus Official Liquidator was disposed of by an order dated 16th August 2023. In view of the above, the Registrar IT is directed to delete the case number BIFR 538 of 1999 within bracket Bengal Immunity versus Official Liquidator from the website of this court. Yes, next. Disposal of Director is type of the suit from the ledger forthwith and department call for distraction. After dissolved. Passed by this court, the company has been dissolved. Therefore, the matter is stand disposed of. The registrar original and the registrar within bracket assistant registrar within bracket in charge company matters department submitted report dated 17 September 2025 wherein it reveals that no case being BIFR 185 of 2000 having cause title Indian Marine Freight Containers versus Export Import Bank of India is pending. He submit as per the report, there was a case being BIFR 185 of 2000 was disposed of on 2000 within bracket Messrs. India Marine Freight Containers versus Export Import Bank of India was disposed of by this court by an order dated 6th of July 2021. In view of the above, the registrar origin side is directed to delete the case being BIFR 185 of 2002 having cause title Indian Marine Freight Containers MFG Limited versus Official Liquidator from the website of this court. Next. Okay. And pending. Disposal. The Assistant Registrar in charge, Company Matters Department, has filed a report wherein it is submitted that no case being BIFR 204 of 2012 is pending. Instead, there was a case being CP number 204 of 2012 within bracket Ram Swaroop Vyapar Limited versus Mrs. Kotak Mahindra Bank Limited was pending before this court, but by an order dated 11th of February 2020, this court has disposed of the said company application. Accordingly, the Registrar IT is directed to delete the case number being BIFR 204 of 2012 within bracket Rameshwar Vyapar Limited versus Mrs. Kotak Mahindra Bank Limited from the website of this court. Next.
But I'm for the applicant.
May I please, Your Lordship, this is my application. Now, there is a substitution application, in respect of a disclaimer application. The original applicant had passed away, and this application is being preferred by his two sons. Now, the sons did not have any copy of the application or did not have the whereabouts of any advocate. So, we had issued a letter to the official liquidator, pursuant to which we were permitted to take inspection. But on inspection, we come to learn that a disclaimer application was filed in respect of a property where the company was company liquidation was a mere occupier, permissive possessor, and the property is owned by my clients, their father. So, in respect of that, we had filed a disclaimer. The father had filed a disclaimer application, but in the interregnum, the father had passed away. So, this is my application, for substitution and for setting aside of abatement, if any.
Who is appearing?
Officially, for officially, I'm a
Yes.
We don't have any objection, Your Lordship, for the substitution.
The death certificate, Your Lordship, is at page 14,
When he died? 2019?
19. But the advocate on record had left profession, and we have been able to get hold of the phone number from the back sheet. And she also did not have any phone number of any other relative, so could not inform of the matter.
The legal heirs of the original applicant have filed the present application, praying for.
And if my lord kindly sees the master judge's summons, my lord.
Praying for recording the death of the original applicant and for substitution of the legal heirs of the original applicant. Full stop. The original applicant died on 3rd of February 2019. Only these are the two legal heirs.
Yes, my lord. There's a will also which we have annexed, which has been probated. We have annexed that also.
Leaving behind the applicants being the legal heirs. Full stop. The Mr. Chen Gupta London advocate submits that though the original applicant has passed away on 3rd of February 2019, but the applicants were not having any knowledge with regard to the pendency of the case. And subsequently, when the applicants came to know, the applicants have approached the present advocate, and on search in the department, the London advocate came to know the application is pending before this court, and accordingly they have prepared an application, they have prepared the present application for substitution of, for recording the death of the original applicant and for substitution of the legal heirs of the original. Learned counsel for the officer liquidator has not raised any objection for recording the death of the original applicant and substitution of the legal heirs of the original applicant. Consider the submission made by the counsel for the respective parties. Peruse the materials on record. This court finds that the applicants have shown sufficient cause for not filing the application within the prescribed period of time. Accordingly, delay is condoned. Abatement order, if any, is set aside, the department is directed to record the death of the original applicant and to substitute the petitioners as applicant number 1A and 1B. 1B within a period of 2 weeks after Puja vacation. How much 2 weeks after Puja vacation? Department will do 2 weeks after Puja vacation.
Yes, ma'am.
Full stop. The applicant, after the name is substituted, we will file the re-verification.
Yes, my lord, I've prayed that, my lord. My prayer F is there, my lord. And the proposed amendment is, my lord, Annexure E.
The applicants are directed to file the amended application.
Upon re-verification.
By re-verification, by re-verification, reaffirmation of the affidavit within a week thereafter. After 7 full stop. After the amendment application is filed, the applicants are directed to serve the amended application to the official liquidator within a week thereafter. Full stop. Please the matter on 3rd of December 2020.
I'm so grateful. But
Yes.
this CA is disposed of.
Yes, disposed of. CA 6 of 2025 disposed.
Grateful.
Grateful, Archer. Next.
So very formal application. My lord, the state my lord had filed an application for disclaimer, which was allowed. My lord, the order, my lord, is at page page 17, my lord, by an order dated 17th August. My lord, there are two, my lord, typographical errors, my lord, in the order, my lord, which need to be corrected, my lord. If lordship is pleased to take the order, my lord, at page 2, page 18, not internal page 2 of the order. My lord, the date of the winding up order, my lord, is mentioned as 26th December 2006. My lord, 26th December, my lord, we are always not closed. My lord, the date should be 22nd December 2006. My lord, I have annexed the order, my lord, of the winding up. My lord, the date of the order is 22nd August 2006. My lord, that is my lord, at 22nd December 2006. My lord, that is at page 10. And my lord, the other correction, my lord, is my lord, if your lordship is pleased to come, my lord, to page 19. My lord, from the top, my lord, item number 5, Cooper Camp, my lord, the area mentioned is 4.18 acres. My lord, that should be, my lord, if your lordship is pleased to take the OL's letter, my lord, last annexure.
No, page 19, which portion?
My lord, at the top, my lord, paragraph, my lord, 5th, my lord, serial number 5, my lord, at the top. Cooper Camp, my lord, this area is 4.18 acres.
Correct.
My lord, kindly come to, my lord, the last annexure, my lord, the letter of the official liquidator, my lord, the area should be actually 11.55 acres. So, my lord, these are the only two corrections, my lord. Prayers A and B, if your lordship says, these are the only two things I've prayed.
We don't have any objection, my lord.
Huh?
If your lordships kindly go through the order dated 17th August 2023. We do not have, my lord, any objection.
Okay, that's the type of
objection.
No, my lord.
So, my lord, prayers B and C, my lord, are only that, my lord. Prayer A was already granted. B and C, my lord.
The applicant has filed the present application for correction in the order passed by this court dated 17th August 2023. Counsel for the petitioner submitted in the order dated 17th August 2023, page number 2, paragraph 2, the date of order is to be read as 22nd December 2006 instead of 26th of December 2006. And in page number 3, item Roman 5, small 5, the area of the land is to be corrected as 11.55 acre ACRES acres instead of 4.18 acres.
That if your lordship could just not mention Cooper Camp at Ranaghat, not serial 5, not Cooper Camp at Ranaghat, not I think that will.
Serial 5, na, with respect of
Cooper Camp at Ranaghat, not that could be. I'm very grateful.
Nadia.
I'm very grateful.
Had the land counsel from the petition applicant and the officer liquidator, this court find that the correction as spread for is formal in nature and also supported by the document. Accordingly, in the order dated 17th August 2023, page number 2, paragraph 2, line number 1, the date of the order shall be read as 22nd December 2006 instead of 26th of December 2006, and in page number 3, item number 5, with respect of the Cooper Camp at Ranaghat Nadia, the area of land shall be read as 11.55 acres instead of 4.
Very grateful.
Okay, this order may be incorporated with the order dated 17th August 2023. The CA 65 of 2025 is disposed of. Next.
Made, please, your lordship.
Yes.
But I am for the official liquidator. But initially, my submission would be there are so many employees' name is here. I do not know. Some of them I have told that some of them has died. So I do not know whether any application has been made for that or not.
Application was is pending, Lord, I'm told. But let me go to Lord, the merit of this matter. I'll be very short.
What's the application?
Lord, this is an application by the company paid employees of the office of the official liquidator. Lord, there was a scheme, Lord, framed by this honorable court. Pursuant to that scheme, Lord, there was an amount which was set apart for Lord for the benefit, the retirement benefit of Lord those Lord employees who are company paid employees. The company paid employees are Lord those class of employees whose Lord the salary benefits come from Lord the companies in liquidation, as opposed to those class of employees who are directly Lord engaged by the government. So Lord, there was a scheme Lord initially framed Lord for Lord the benefits of Lord the company paid employees on the premise their services were not very unregularized and Lord they were not getting Lord their pay according to Lord the service that they are giving it Lord in parity with the other Lord the employees of the office. Lord?
Parity.
Lord, that was Lord the scheme was trying to achieve. A scheme was trying to achieve that Lord the service benefits and somewhat Lord the parity. Now the applicants before your lordship comes, Lord, I am just summing up the matter to say that Lord, by virtue of order of this honorable court, Lord, certain Lord employees of Lord the company, Lord engaged employees, Lord, they were given Lord certain benefits on their superannuation. Lord, this particular order, Lord, had a particular Lord a connotation to say that Lord, the benefit of the order will Lord accrue only to those who were in employment as on the date of application. I am a similarly circumstanced employee. My contention is Lord, the scheme was floated when I was in employment. Therefore, as on the date of retirement, Lord, the scheme was there.
When the scheme was framed?
Lord, I'll give your lordship the date, Lord. Lord, it is at page 35A. Lord, it was in 31st of January 1992.
92, and you are in service at that point of time?
Yes, we were.
You are in service?
We were. And even after that, Lord, we have retired, Lord, in 2013.
Yes.
Lord, this was Lord pursuant to Lord an order passed by this honorable court, Lord, in modification of the scheme, which was initially framed in 29th of June 1972.
First order.
35A, your lordship's got that. So, Lord, whatever your lordship will kindly have a just cursory look into Lord what it says. Lord, it was trying to Lord govern the service condition and Lord the benefits. TA, DA, LTC and all.
Yes.
Then from time to time, Lord, another order is at page 39. Your Lordship will find, Lord, the terms and conditions are also, Lord, governed by the orders passed by this Honorable Court, either on an application by the office of the official liquidator or, Lord, by the employees themselves. Page 39A, Lord, is
So now what the pay they are getting now?
Lord, I'm not on pay. Lord, I say that the ex gratia that was given, that should also be extended to.
When you retired?
Lord, in 2013.
Yes, my lord, if it is done, my lord, if your lordships allow, then my flash gate will be open.
Got another 5
Everybody
minutes of my
will
side. I'll complete within 5 minutes, because then your Lordship will kindly come to the order at page 40. This was not the establishment of the initial fund, because I am asking for payment out of this fund. Considering the submission made by the official liquidator and considering the averment made in the letter for direction submitted before this court is of the view that the liberty may be granted to the official liquidator to create a separate fund to be known as Official Liquidator's Establishment Charges Account for payment of salary of company paid staff and other allied establishment charges, and keep the in savings bank account with any scheduled bank. The leave is also granted to the official liquidator to withdraw an amount of rupees 10,58,000 from the PL account and deposit the said amount in the aforesaid account open. So I only say that there is a specific fund where there is a specific accrual. Out of this, but your Lordship will kindly, come to order passed by my Lord Justice I.P. Mukherjee, Lord, at page 145. There are few other orders in the meantime. If necessary, I'll take your Lordship to those.
142,
145. 145.
Yes.
There is a Supreme Court order, only the operative portion I'll show. This application has been made by the company paid staff attached to the office of the official liquidator of this court. The following prayers are made. Leave be granted to serve a copy of this application to the Regional Provident Fund Commissioner, the Employees Provident Fund Organization, such and such. Official liquidator, Calcutta High Court, be directed to frame a suitable scheme for pension-linked provident fund, such and such. But this court is aware of the uncertainties of life which is faced by the employee. The uncertainties are more in case of a company paid staff in the office of the official liquidator of this court, because their service has never been regularized. There is no scope of getting pension. All that a superannuating employee is provided is gratuity and some other minor benefits. However, each one of them has rendered long uninterrupted and unblemished service in the office of the official liquidator, not in any way inferior to that of regular employee would have given to the organization. Out of a long-standing practice, a percentage of the sale proceeds realized on sale of the assets of the company in liquidation is appropriated by the official liquidator to pay the expenses of office, including the salary and other allowance of the company paid staff. These employees were never paid a single rupee out of any fund of the central government. The official liquidator has reported to this court that if part of the fund in his hand is allocated by this court to provide a one-time post-retirement or death benefit to these employees or their immediate family members, the day-to-day functioning of his office would not be impaired. After coming into force of the Companies Act 2013, it is not possible to estimate how long the office of the official liquidator would continue. In those circumstances, in my view, the official liquidator's office should not take the burden upon itself of providing pension to the employees or to the family members of the deceased employees. In those circumstances, after considering the fund position in detail at present, and its expected position in future, taking into account the liabilities present and future and contingencies, I direct the official liquidator to set apart a sum of rupees 11 crore 14 lakhs in a term deposit. In my opinion, this fund should be utilized for making a one-time ex gratia payment to each of the 128 employees, except any employee denied this benefit in a disciplinary proceeding in accordance with the table which is set out as a schedule to this order. But thereafter, Lord, the table has been, Lord, appended to that order, and then kindly come to 156. In the said table, the employees are divided into 3 categories according to the post or rank held by them. The ex gratia payment to each of the category is also specified, namely 8 lakhs, 6 lakhs, 4 lakhs. All the employees who were in employment on the date of affirmation of this application are eligible to this benefit. But this is not why I say this is. But in case of death of an employee, the benefit would go to the legal heirs or heirs.
Yes.
But all that I say is that, not since this order not only confined to the applicant, and I am a similarly situate person, this is coming out of a separate fund of the office of the official liquidator, that one-time ex gratia payment according to the length of my service should also accrue to me. This people have
not the applicant before the court.
My lord,
You are not the
I was not the applicant before the court in that particular matter.
okay. And this order was passed when?
But this order was passed in 2017.
8 July 2017.
17.
And
When
this
you
was
retired?
in 2013.
Before
The only catch, I tell your lordship, your lordship has asked me the right question, Lord. This application was taken out by those class of employees who were still in employment.
Correct.
I was not. But nevertheless, although I was not an applicant, but I stand in the same footing as those who have been not given this benefit of the order.
Yes.
So, Lord, now, Lord, there was an issue about, Lord, the company paid staff of, Lord, the office of the official liquidator, Lord, claiming, Lord, their absorption. This went up before the Honorable Supreme Court. The Supreme Court order is at page 42. Your lordship need not, Lord, trouble your lordship with that. Lord, kindly come to, Lord, the last portion of the order, 129. Supreme Court did not grant them, Lord, the relief that what they have asked for, but was very sympathetic with their cause. And pursuant to that, Lord, the orders followed from this honorable court in their cause. 129.
Yes.
Paragraph 94.
Yes.
Then, Lord, thereafter, Lord, the orders, Lord, followed to page 132 and all. Lord, that is all for my case. Now, Lord, so far as, Lord, the relevant pleadings are concerned, page 22, paragraph 36 onwards.
Page 22.
32, Lord. 32. 22, I'm sorry. Page 22, paragraph 36. ছোট প্লিডিং দেবী কোথায় কি কত টাকা পেয়েছে সমস্যা হলো তোর এই হিউজ প্লিডিং
Yes.
But this is all for me.
Yes. What is your contents?
Lord, I have already stated that they have retired, my lord, 2013. They were not in employment when the order was passed. And the order was passed specifically, if your lordship kindly takes my written objection.
उनको objection है? Affidavit है?
There are two written objection. One is 11th December 2023. And 7th day of August 2018. Anyhow, my lord, kindly see 2023, my lord.
December 23.
December 23. My lord, may I place the page 6, my lord, paragraph 3. 23.
Yes.
Yeah.
Soft copy আছে লাগবে এখন একটা আছে
Thank you. Kindly see, my lord. Yes, yes. But what I have stated, my lord, the first category comprises, my lord, A, my lord, in the employees who are the government staff appointed against the post sanction by the Government of India, Ministry of Corporate Affairs, their salaries and allowance are paid from the Consolidated Fund of India. Then, my lord, B, the second category comprises persons employed engaged in by the official liquidator to mitigate the exigencies of the work in this office pursuant to the sanction accorded from time to time by the Honorable Court under Rule 308 of the Companies Court Rules 1959. The employees of these categories are described as company paid up staff. Their salaries and allowance are paid from the official liquidator's establishment charges account created under the Honorable High Court's order dated 5th April 1990 by segregating 30% of the interest income received from the bank from time to time on the fixed deposit made from realization of the sale proceeds in respect of the assets of the companies. At present, there are 15 heads of government staff, including 3 officers and 66 heads of the company paid up staff. That is, my lord, according as per 23. The present application has retired company paid up staff in the office of the official liquidator High Court Calcutta, as it appears that they have been retired before filing this application, being CA number 224 of 2014. Upon their retirement from the service and upon accepting the due benefits thereof, as per the then scheme of retirement, as framed by this Honorable Court, the applicants are not entitled to have further service benefits from this office. At all material points of time, the said applicants' company paid up staff have retired from their service with following benefits: gratuity, leave encashment on retirement. In the year 2014, temporarily long after retirement of the applicants, the existing company paid up staff filed an application being CA number 224 of 2014 before this Honorable Court, praying inter alia to grant provisions for the pension scheme for them out of such establishment funds. The aforesaid application was allowed by the Honorable Court by an order dated 28th July 2017. My lord, that order, my lord, is page 21, annexure A. Your lordship has already possibly...
That is the order.
That is the order, my lord, page 21.
Yes.
So this order, my learned friend has already submitted this order. The present applicant's petitioner raised urge for similar benefit, barely devising in the said order dated 28 July 2017 as a tool to operate in their favor. All such applicants' petitioners have duly been retired as per the prevailing service conditions with retirement benefit as gratuity and leave encashment on superannuation under terms of the official liquidator and the solemn order of the Honorable Court. I say that the said order dated 28 July 2017, this Honorable Court aptly observed that all the employees who were in employment on the date of affirmation of this application CA number 224 of 2014 are only eligible to benefit. So, my lord, that benefit was granted those who have made application. Now, if your lordship thinks we today, if your lordship allow them as they are asking for, then, my lord, the floodgate will be opened. Then who has retired 2010, 2000, everybody will come. Then how the money will be paid? Where from the money? Because this money is being, my lord, lying with the official liquidator office out of the sale proceeds. Because in view of the order of the Honorable Justice, the then Honorable Justice Padma Khastagir, my lord, some interest portion out of the sale proceeds are being kept to run the day-to-day office of the official liquidator. Now, my lord, these benefits, as of the date, they have already admitted that they have retired and they have opted the then benefits they have availed. Now, my lord, today, if any order is being passed in their favor as they are asking for, then, my lord, tomorrow some employees, my lord, they will also come, they will also make an application that they are also entitled to get the benefit. That is all about with regard to that. So this order, which order has been passed, that order was passed only to those applicants, those who have made this application. So subsequent, there is no order and they cannot possibly get the benefit because they have retired much prior to the date of the order.
Okay. That's all?
That's all.
The office of the official liquidator do not disclose in their affidavit in opposition as to their fund position. This is a particular fund for payment to the company paid employees. Now, we find from the recorded order, in 2017, there was a substantial amount, which was in the fund, only for the purpose of, payment to the company paid employees. Out of which, how much has been paid to, the applicants of, that application, that has not been, disclosed before your lordship. Now, if a particular benefit has been given to particular employees at that point of time, and when I stand in the same footing, I expect that the same the benefit should also accrue to me. In the absence of that they are pleading that they do not have anything in the fund, the things could have been otherwise. We do not find anything in their opposition to say that we are unable to at least financially pay to my clients who are 8 in number only. There were 128 or 124 applicants at that point of time. So that is my basic submission before your lordship. And also, that in the opposition, they do not say as of today, how many company paid staff are still in employment, how many have already retired, and we find that the applicants, the name and the number from the order and the tabulation statement contained.
Okay, thank you.
Lordship.
ये जजेस सम्मन जजेस सम्मन है eight numbers of retired company paid staffs have filed the present application, being CA number 192 of 2018 in CP number 4 of 1956, praying for an order directing the official liquidator of this court to include the name of the applicants with the scheme framed for one-time ex gratia payment in terms of the order passed by this court dated 28th of July 2017 in CA number 224 of 2014 in CP number 4 of 1956 and to make payment to the applicants. Mr. Prabal Mukherjee, learned senior advocate appearing for the applicants, submit that company paid staffs have initially filed an application being CA number 2224 of 2014, praying for a direction for framing of a suitable scheme for pension linked provident fund facilities with the assistance, please take it, with the assistance of the Regional Provident Fund Commissioner, the Employment Provident Fund Organization for existing company paid staffs and leaving retired company paid staffs and to introduce the same immediately. This court by an order dated 28th of July 2025 and 2017 has disposed of this said application by passing the following order. Invert comma. In those circumstances, after considering the fund position in detail at present and its expected position in future, comma, taking into account of the liabilities present and future and contingencies, I direct the official liquidator to set apart a sum of rupees 11, 14, 00, 000 in a term deposit. In my opinion, this fund should be utilized for making one-time ex gratia payments to each of 128 employees, except any employee denied this benefit in the disciplinary proceedings in accordance with the table set out in the set off. As per the table, the employees are divided into three categories according to the post or rank held by them. The ex gratia payment to each category is also specified, namely 8 lakhs, 6 lakhs and 4 lakhs. It is further clarified that all the employees who were in employment on the date of affirmation of the application are eligible to the said benefit. In the case of death of the employee, the benefit would go to his legal heirs, After the order passed by this court, the official liquidator by an order dated Have you framed the scheme? Have you framed the scheme? In terms of that order, there is any scheme or not?
No.
Only directly you paid the amount.
Yes.
In terms of the in terms of the order dated, 28 July 2017, the company paid, the official liquidator has disbursed the amount to the company paid staff. Now this petitioners came before this court for the similar relief. Mr. Mukherjee, learned senior advocate, had drawn the attention of this court to the order passed by the Honorable Supreme Court, wherein the Honorable Supreme Court has directed that the salaries and allowances payable to the company paid staffs should be suitably increased in the wake of huge escalation of living cost. Learned advocate appearing for the applicant submit that in terms of the order passed by the Honorable Supreme Court, the official liquidators have implemented the same by increasing the monthly intense has paid the salary and allowances as per the escalation cost of living, but living, and subsequently in terms of the order dated 28th of July 2017, the employees have been paid the ex gratia payment, but these petitioners who had worked as a company paid staffs, but unfortunately they have retired prior to the order passed by this court, have not been granted the benefit of the said order, and as such these applicants are also have also worked as a company paid staff and have retired from the service and are facing some difficulties to survive their lives after the retirement, and as such the benefit granted by this court by an order dated 28th of July 2017 may be awarded to the retired company paid staff. Learned Counsel appearing for the official liquidator submit that the company paid staffs have filed the application in the year 2014. These applicants have retired from their service prior to filing of the application. And as such, and if at this stage this court has allowed the official liquidator to pay the ex gratia payment in terms of the order dated 28th of July 2017 to the retired employees, comma, it will be floodgate to all the retired employees who have been retired 10 or 20 years before, will come before this court and pray for the parity and pray for the similar order for grant of ex gratia payment in terms of the order dated 28th of July 2017. And the official liquidator would not be in a position to pay any amount. Full stop. He prayed for dismissal of the application. Heard the learned counsel for the respective parties peruse the materials from the court. Admittedly, the petitioners before this the petitioner who filed the present application praying for ex gratia benefit in terms of the order passed by this court dated 28th of July 2017 have retired in the year 2013, that is prior to the application filed by the applicants in CA number 224 of 2014 and prior to the order dated 28th of July 2017. In the said application being CA 224 of 2014, the applicants have also prayed for the benefit for the retired company paid staffs. This court, by passing, have disposed of the said application by an order dated 28th of July 2017. And by disposing of the said application, this court categorically held that the ex gratia payment to be made to each of 128 employees except any employee denied his benefit in the discipline proceeding in accordance with the table in which set out in the schedule of the order. This court, though the applicants of 224 of 2014 have prayed for the benefit of the company paid staffs, but while disposing of this application, this court has not granted any relief to the retired company paid staffs. Now, after this period of 4 years, the applicants have filed the present application praying for this benefit. This court find that the applicants who were in service have filed the application for grant of benefit or grant of ex gratia benefit, and this have filed an application praying for suitable scheme for pension, but this court, instead of a scheme for pension, has granted ex gratia payment, and that has been complied with by the official liquidator. Considering the above, this court find that the applicants have already retired in the year 2013 or earlier and prior thereof, and the company paid staffs have filed the application in their 2014, and this court has disposed of the application in 2017. And in this said application, the company paid staffs have also prayed for a relief for the retired company paid staff, but this court, by an order dated 28th of July 2017, has not granted any relief to the retired company paid staffs, and thus this court find that the applicants are retired in the year 2013, that is prior to the application filed by the company paid staffs, and the order was passed in the year 2017. By that time, these applicants were retired. Thus, the applicants are not entitled to get any benefit of the ex gratia payment in terms of the order 28th of July 2017. Accordingly, CA number 192 of 2018 is disposed of. Sorry.
Much obliged.
I'm for the official liquidator.
That I appear on behalf of the applicant, my lord.
Yes, what is the application for?
My lord, this application is essentially filed on behalf of the secured creditor seeking for disbursement, my lord, of the amount lying with the official liquidator.
What is the stage?
My lord, I think the settlement is in progress, my lord. Official
Settlement between whom?
only one. He has only lost
Secured
the
creditor, he has filed an
I am the
application for
only.
disbursement. What is the settlement now?
My lord, the affidavit was filed before the official liquidator on 4th September 2024. A letter was also forwarded from our end to the official liquidator requesting for settlement on 30th
What is
September
your
20.
claim? What claim
My
you
lord,
made?
my claim in terms of this is an assigned account, my lord, from State Bank to Kotak. So the initial claim, my lord, was for 93 lakhs. The official liquidator in its report indicates that there is a figure of round about 88 lakhs lying with them. So the amount which is there, my lord, is more or less akin to the claim which I have, my lord. So this report, my lord, is a year back. So I don't know what the figures as on date would be.
What is the situation?
This on 24th July, this order has been passed to adjudicate. So the matter is adjudicated. We are
Yes, yes.
progress to adjudicate.
Who has passed an order for adjudication? This
My lord,
court.
Justice Samant, Shubhendu Samant.
Give the order.
Pursuant to this order, advertisement was made.
Advertisement for what?
My lord, inviting claims. So apropos that, my lord, we had gone and submitted our claim.
So this is July 2024. Paper publication was made.
Yes, yes.
Claims and objection was called.
Yes, yes.
When?
It was published on 5th August 2000.
So what has happened after that? After publication, any claims and objections?
Only they have lost the
Only
claim.
they have lodged. So why not adjudicated?
Some original documents.
My lord, we have already filed.
Whatever it is,
Yes, yes,
dispose
yes.
of, file a report. If then the court, if you are not able to decide, then court will decide. If you are difficulty with regard to acceptance of the document, file the report, serve the copy, let them come here. The court will decide whether that is acceptable or not.
Well, some more time may be given so that.
Like that 2019 88
Yes, yes.
case. Once it has been disbursed, automatically the case would have been disposed of. So
I understood.
88 matter. Who will give the answer to the Supreme Court? Why you are the 88 matter is pending here?
No,
How much
because
time?
the appeals were pending.
Whatever it may be.
2 weeks time, sir.
2 weeks time. So I am fixing on 12th December by 12th November it will be over. There's a puja vacation.
Yes, sir.
12th November.
Let it be 1 week after vacation.
19th November.
19th November.
19th November.
Yes, yes.
Record an order. The applicant. Who are you?
My lord, I am on behalf of Kotak Mahindra Bank, my lord, the only secured creditor.
The secured creditor, namely Kotak Mahindra Bank, has filed the present application, praying for a direction upon the official liquidator for release and disbursement of an amount of rupees 88,02,439. Full stop. The counsel for the official liquidator submits that in terms of the order passed by this court dated 26th of July 2024, a publication was made for claiming claims and objection. And after the publication, the petitioner has filed a claim before the official liquidator. The official liquidator prays for 2 weeks' time to dispose of the claim raised by the secured creditor. Full stop. In view of the above, the official liquidator is directed to decide the claim of the applicant within a period of 2 weeks and to submit the report before this court on 19th of November 2024 after serving the copy to the learned counsel for the secured creditor. This is the matter on 19th of November 2024.
Grateful, my lord.
Next.
I'm appearing for the RP.
Appearing for?
RP, Resolution Professional.
Resolution Professional.
This is the
What
matter
is the duty of the resolution professional here?
This is the Avni matter. The whole
Avni matter, okay.
I am for the applicant for CA 81 of 2024.
Any settlement, any deed registered in the meantime?
No, no, Your
No.
Lordship.
So,
My lord, in item 6, I appear for the applicant. Payment has been made by my client.
now deed registered.
No,
Item
deed has-
19 CA6.
Deed has not been
Now,
registered.
deed registered?
No.
No, that's why if any deed registered, otherwise I will keep pending.
Yes.
Let the deed registered. I am
Yes.
keeping after on 12th of November.
Yes.
In the meantime, if the deed is registered, come and I will
If
dispose.
my lord can direct the RP to do the execution in a time-bound manner.
He'll do it. He'll do it, Your Lordship.
Already Mr. Banerjee has
Yes.
undertaken.
We have also done the payment of 50,76,500.
So how many payment is due?
No payment is
No
due.
payment is, yes, the parties who have already made the payment, make a request to the RP regarding the evidence of the making the payment, and they will register. They will not register, come on the next date.
Yes. Yes, Your Lordship.
Made the request.
And she have made the payment. If you also kindly mention that indictment, the payment has been made, then the deed can be registered, then we can proceed.
So, which matter to which matter? The Avani matter is there?
19 to
19 to
33.
30?
33.
And item number 44 also same matter.
My lord, item
33.
19 also.
33.
19. My item is 19.
Up till which matter the Avani matter is there?
46, Mala.
46.
Item number 44 also.
Oh, 46. Still 46.
Item number 21 and 39, my lord, we have made payments.
Okay, I am passing a common order.
What I was seeking your lordship is that, my lord, had item number 39 has been filed by one outsider asking before your lordship not to register the deed in my favor. My lord, I was appealing in the meantime, let me file of affidavit in that regard.
Which matter?
Item number 39 and 21. 21 is my application seeking registration, my lord. 39 is his application seeking before your lordship.
21 and 39.
Yes, my lord.
Okay, let me see. Item number 19 to 40, 46.
Yes.
46 except 21 and 39. Okay. The counsel for the respective parties submits that they have paid the total sale consideration. Total sale consideration.
Yes.
Have paid the total sale consideration. In view of the submission made by the counsel for the parties, the parties are directed to submit the details of the payment made by the parties with regard to the property in question to the IRP within a week from date. RP kar do. RP within a date from date, and on receipt of the representation and the documents from the parties regarding the payment of total dues, the RP is requested directed to register the deed as early as possible within a period of 2 weeks after getting the information with regard to payment of the total dues. Full. Let all the matters full stop. The parties are directed to communicate this order to the RP for compliance.
Grateful, my lord.
3 weeks at least, because the my
क्या बोलना?
vacation begins. And it's not open until Lakshmi Puja.
नहीं ऊपर first में कब? The petitioner, the parties are directed to communicate within 2 weeks. Within 2 weeks. Within 2 weeks from date. Two weeks now, 4 weeks. 4 weeks.
Grateful.
From the parties. Okay. Communicate this order to the RP. List the matter on 4 weeks. List the matter on 10th of December 2025.
Grateful, my lord.
तो 46 पे एक्सेप्ट 46 उसमें बोला 46 को हटा देना, उसको देना लिखना नहीं. 19 to 45. Yes, next.
My lord, with regard to item number 21 and 39, my lord.
Yes, 21.
21 is my
Your application for
registration of that.
and 39 is
39 is, my lord, my application.
not to register.
Not to register, my lord.
What I was
Both file the affidavit.
my lord, let me file affidavit because he has already filed a suit before the learned court at Barashat, my lord. I need to bring all those documents on record.
Okay, both the party filed their affidavit.
Meanwhile, his CA may be, my lord, the petition may be served on me, my lord.
I
because
shall
I thought-
definitely, I will.
Recorded
Sorry,
21 and 39.
39, my lord.
The counsel for the, you are for the 39.
For third.
Counsel for the applicant appearing
I am led by Mr. Rupako.
in item number 39. Raise for a direction for service of copy of CA number
9 of 2019, my lord.
9 of 2019.
21, my lord. Item number 21, it was.
No, 39. He isn't.
I am in 39, lord.
You are 21 is not been served.
Yes, 21 has not been served on me.
CA number 9 of 19. Full stop. Full stop. The counsel for the applicant in CA number 9 of 2019 is directed to serve the copy of the application along with the document to the learned counsel appearing for the applicant in item in CA number 74. Your application
Yes,
74. 24 within by which time?
By next week, my lord. I shall have it.
Within a week from date. Full stop. Both the parties are directed to file affidavit in opposition within 2 weeks after puja vacation.
My lord.
Reply if any there to be filed within a week thereafter. Full stop.
Kindly makes it 2 weeks, my lord, the reply, my lord.
2 weeks thereafter.
My lord, okay.
2 weeks thereafter. List the matter on 3rd of December 2020.
3rd December, my lord. Grateful lordship.
Lordship.
Yes, next. 46 over. 45 over. Then 46.
I am for the official liquidator. This is an application filed by the security guard.
Yeah, where is he?
I do not know. Last occasion also.
Not today. He's not interested for payment. What
Why
is
not?
better? Yes, next. Not today.
This matter.
No applicant.
Yes.
Not today.
No, my lord, I am for the official liquidator.
Ah.
My lord, your lordship's direction was to get the statement of quotation, my lord, regarding the software, installation of software.
That one.
Yes, my lord, may I
Have you got that?
Yes, my lord, I have got this. My lord, there was a meeting.
You do one thing. You file in on affidavit by way of
Very well,
report.
my lord, that would be better.
File the report.
Yes.
Counsel for the official liquidator press for time to file report in terms of the order dated 6th August 2025. Let the report be filed within
1 week after vacation.
Within 1 week after puja vacation. This is the matter on 12th of November 2023.
But item number 47, 48 and 49.
Same
matter.
47, 48, 49. Next. $50.
I am for the applicant in item number 51, my lord. On last occasion, lordship directed.
51.
51.
50, 50, half century.
50 and 51, my lord. Both, my lord.
Yes.
On last occasion, your lordship directed to file an affidavit stating the heirship and the death certificate.
In view of the above, applicant Sanjay Kumar Sureka is directed to file supplementary affidavit disclosing
I have
the death
served and I have
certificate of Ratanlal Sureka, his wife Rajkumar Sureka and his wife. All the legal heirs of Rajkumar Sureka, namely so and so, daughter so and so, shall also file affidavit disclosing the details. Yes.
My lord, I have filed the affidavit, my lord.
Lordship, I appear the
But I am led by Mr. Rahul Kaur.
we have received the affidavit, Your Lordship. We have not gone through the affidavit. We need some time to go through the affidavit, Your Lordship.
Huh? Have you received the copy?
Yes, Your Lordship. We have received the copy. but we have not gone through the affidavit, your lordship.
Here is what your lordship would recall. Flood.
Yes, yes.
Flood, it was upon your lordship's flood.
Come on,
pleasure.
come on, 24. Come on, 24.
2 weeks times can be granted, your
Why? This is benefit. The person's benefit is lying in your office.
Your lordship, that was my direction to seek 2 weeks
Huh?
time. Your lordship, my direction was to ask for 2 weeks time. your lordship.
What you will do? The court will verify the document. What you will verify? What you will verify?
Lordship, then 1 week, your lordship.
Come on, 27. Come on, 27.
Grateful, your lordship.
24. Come on, 24. The applicant has filed affidavit, 3 affidavits. In terms of the order dated 20th August 2025, after serving the copy to the official liquidator, let the same be kept with the record. The official liquidator, counsel for the official liquidator prays for a week time to go through the affidavit filed by the applicant. Let the matter appear on 27th of August 2020.
Oblige,
27th September.
But 24th.
24. Yes, next.
Oblige.
My lord, I am appeared for the applicant.
Milord, I appear for Milord Mr. Otonu Dotto, Milord, the other respondent.
This is my application.
Milord, the connected matter, Milord, has kept on 12th of November, Milord.
This is a separate matter, my lord. There are direction on the official liquidator to submit the surveyor report, my lord,
The
regarding
report is with
demarcation.
me, my lord. The wrong brief has been, my lord, given, my lord. Kindly keep this matter, my lord, next.
A copy may be
I
handed
will, I
over.
will hand over a copy, definitely.
As per
It a
the,
copy, Milord, circulated, Milord.
the request made by the counsel for the official liquidator, case adjourned, let the matter appear on 24th of September. So the copy.
In the meantime, Milord, copy be Milord.
Yes, sir.
Yes, I shall, sir.
Very good.
I'm deep.
Very good.
Grateful, your lordship.
My lord, interim order is, my lord, extending today.
Which matter?
I don't know, 144 and 146, my lord.
144?
I'm for the ROC, your lordship, in these 2 matters, 144 and 146.
Yes.
The interim order extending, expiring today, my lord.
Yes, madam.
Your lordship, Mr. Banerjee, learned senior counsel, had made submissions on the last occasion, your lordship, in these 2 matters, and it is a part heard matter, your lordship.
As per the 144, 145, 146.
My lord, 144 and 146.
144,
No,
140?
44 and 46.
144 and 146.
145 nahi hai. As per the prayer made by the counsel of the applicant, the interim order is extended till 12th of November 2025 or until further order, whichever is earlier. Let the matter appear on 12th November 2025.
12th November, your lordship.
Yes, Mr.
Milord, I've been asked to mention on behalf of Bharat Petroleum. Well, this is a contempt. The advocate on record could not be present. Lordship has issued against finance director and HR of Milord. We have filed recalling application. I'd be grateful if you constitute before the it's fixed on 24th. Milord, I'll be grateful if it's entirely for you.
Fixed on
24th, my lord. We have filed applications.
Okay, no. You have made the request to the Chief Justice.
Yes.
Chief
But
Justice office.
from day one, my lord, he also
Made the
mentioned.
Chief Justice. I think the record will come. Then I will talk to my learned
Please,
brothers and
please, my lord, that is all. My lord,
My lord,
we
the
have
rule
filed
has been issued and the rule has been made returnable on the 24th.
I know. We have filed application
Correct. Now they on the earlier occasion you appeared. He has mentioned
Yes.
the matter before this court.
Fine.
So but singly I cannot take the
No, no.
decision. So that's why you have not
That's
taken a
what I
decision.
said.
Then they made a request to the office of the Chief Justice.
Because my lord
Now
is a
I
senior
think
judge. I mean, this
now
is a
I think the
request.
matter will be marked to me. Then we'll see to that, and I will talk to the
And
my
that's-
learned brother will see to.
Well, I'm sorry to mention.
No, it's okay.
May I have your lordship kindly to mention, my lord, item number 78 of the Lordship's Commercial Division list.
Item number
78, my lord.
Commercial Division.
My lord, I appear for the defendant.
Extension of interim order, my lord.
My lord, here
Order is to expire today.
only one submission, my lord. Will record my formal opposal at least. We have preferred an appeal against my lord's original ad interim order. My lord had stayed, my lord, certain notices whereby we had recalled the loan. My lord, recall Money Square and my lord, Piramal Housing. my lord, we've challenged that order, my lord. On Monday, it was no. I'm not saying that, my lord. My lord will of
And
course.
stay granted.
No, it was adjourned at the instance of the plaintiffs on Monday. It was taken up on Monday. They had sought a not today. My lord, we did not oppose. My lord will extend the interim order. My lord will record my formal, my lord, objection to it.
Item number?
They have not filed the affidavit.
Item number?
78.
We preferred
Malad,
an appeal.
commercial dispute. Only GA1. Malad.
78. Counsel for the plaintiff raised for extension of time to interim order. Counsel for the defendant number?
1 and 2.
1 and 2 raise objection and submit that he has prepared an appeal. At the learned counsel for the parties, the interim, it is found that no stay has been granted.
They have not filed any affidavit also, Malad.
Consider the submission made by the counsel for the parties. The interim order is extended till 11th November 2025 or until further order, whichever is.
My lord, in this same suit, I filed another application, my lord, for further interim order. Your lordship has stayed the recalling of the loan. I am tendering the payments for the upcoming installments, my lord. They are refusing to accept, saying no, notwithstanding your lordship's order, that the entire facility is recalled, so they will not accept. So, my lord, GA2 I have filed. If your lordship will kindly take that up, my lord.
My lord, let it come up on that.
The matter remain.
My lord, that is also listed with item.
The matter remain in that.
My lord, only. My lord,
Let the matter remain in the list.
Grateful, my lord.
Item number 140 of your lordship non-commercial list. Now, this is a application by the court liquidator, assistant court liquidator. Assistant court liquidator for payment of the
148.
140 of non-commercial list.
Non-commercial list. Company matter.
But this is in respect of an application has been filed by the assistant court liquidator for payment of ex gratia amount to the employees which is paid before the puja vacations. Puja vacations are coming, your lordship.
Puja what ex gratia payment?
For every year it is paid, just before the puja vacation.
So why you not mention the only?
I was just
all left. How the order can be passed here? When the puja starts?
26th is the last.
So come on 24. एक काम करो 24 को ना इसको ऊपर कर दो. Topic. 2 PM फिक्स है ना? 2 PM भी है. तो 3 उसका बात कर जब शुरू होएगा उसके बाद.